The Civil Code of Cambodia. Chapter 7 Easements. Section I General Rules. 670. Definition of easement. 1. An easement is the right to use the land of another for the benefit of one's own land, in accordance with the purpose specified in the contract of creation, provided that an easement may not be created that contravenes public order. 2. The other person's land that is used for the benefit of one's own land is referred to as the servient land, and the land that enjoys the benefit of the easement is referred to as the dominant land. 3. A perpetual lessee or usufructuary is also entitled to create an easement using the subject land as the dominant land. 286. Formation of easement. 1. An easement may be created by writing or otherwise. 2. The owner of the servient land may at any time give notice of the extinguishment of an easement that is not in writing. In cases where the time of extinguishment of the easement is not stated in the notice of extinguishment, or where the period stated, counting from the date of the notice, until the date of extinguishment is less than 1 month, the easement shall be extinguished upon the lapse of 1 month, counting from the date of the notice. 287. Requirements for perfection of easement. 1. Unless an easement is registered, it cannot be held up against third parties. 2. An easement that has been registered may be held up against a person acquiring the servient land. 288. Scope of persons entitled to enjoy the benefit of an easement in addition to the owner of the dominant land, a lessee, perpetual lessee, usufructuary or holder of a right of use or right of residence over the dominant land is entitled to enjoy the benefit of an easement, except where otherwise provided in the contract creating the easement. 289. Appurtenant nature of easement. 1. An easement passes along with the ownership of the dominant land if the ownership of the dominant land is assigned, except where otherwise provided in the contract creating the easement. 2. An easement may neither be assigned nor made the subject of other rights separately from the dominant land. 290. Obligations of the servient land owner. 1. The owner of the servient land must not obstruct the exercise of the easement or do anything that reduces the utility thereof. The owner of the servient land may not change the land that is originally agreed to be the servient land to other land without the consent of the easement holder, provided that if continuing to use the original servient land as the servient land would cause severe detriment to the owner of the servient land due to change to circumstances occurring after the establishment of the easement, said owner may offer other land as the servient land that is beneficial to the same degree to the dominant land. If the easement holder does not consent to this, a judgment may be sought from the court in lieu of the said consent. 291. Obligations of the easement holder. 1. The easement holder may not use the servient land beyond the scope provided in the contract creating the easement. The easement for using the water created at a water source includes the right to way over the land where the water source is. 2. The easement holder may not alter the servient land or the dominant land in a manner that could have serious adverse impacts on the condition of the servient land. 3. If the easement holder breaches the provision of the first sentence of paragraph 1 and paragraph 2 above, the owner of the servient land may apply to the court for extinguishment of the easement. 4. An application for extinguishment under paragraph 3 above shall not preclude a claim for damages in tort against the usufructuary. 5. If consideration is prescribed for the easement and the easement holder does not pay the prescribed consideration, the owner of the servient land may apply to the court for extinguishment of the easement. 292. Right of easement holder to erect structures on servient land. 591. The easement holder may erect structures necessary for the exercise of the easement on the servient land. Upon extinguishment of the easement holder shall remove such structures and restore the servient land to its original condition. 592. To the extent that this does not obstruct the exercise of the easement, the owner of the servient land may use any structures erected on the servient land for the purpose of exercise of the easement. 593. In cases described in paragraph 2. The owner of the servient land shall share the costs of erecting and maintaining the structures in proportion to the profits it receives. 293. Allocation of expenses of structures. 1. Unless otherwise provided, the owner of the dominant land shall pay the expenses of erection and maintenance of structures necessary for the exercise of the easement. If there is special agreement for the owner of the servient land to pay the expenses of erection and maintenance of structures and such agreement is registered, the burden thereof shall pass to any person who acquires the ownership of the servient land. 294. Easement holder's real right of claim. An easement holder may exercise the same rights to demand return, to remove disturbance and to prevent disturbance vis-à-vis an infringement of the easement as the owner. 295. Relinquishment of ownership of servient land in favor of easement holder. 1. Where these is special agreement for the owner of the servient land to pay expenses under Article 293 allocation of expenses of structures, said owner may at any time be released from the burden of such agreement by relinquishing the ownership of that portion of the land that is necessary for the easement to the easement holder. 2. Relinquishment refers to the relinquishment by the owner of the ownership of the servient land based on his unilateral declaration of intention and the transfer of such ownership to the easement holder. 296. Prescription of the term of easement. 1. Where a term is prescribed in the contract that creates the easement shall be extinguished at the expiry of such term. 2. Where a term is not prescribed in the contract of creation of easement, the owner of the servient land may apply to the court for extinguishment of the easement. The court shall decide whether to extinguish the easement or not, by considering the facts such as the circumstances of the creation, the execution in the past, existence or inexistence of the consideration. 297. Extinguishment of easement due to the complete destruction of the dominant land. An easement shall be extinguished in case the dominant land is completely destroyed. 298. Extinguishment of easement by co-owners. 1. A single co-owner of the dominant land may not extinguish an easement in respect of his share. 2. A single co-owner of the servient land may not extinguish an easement in respect of his share. 299. Subdivision or partial assignment of land and easements. 1. If the dominant land is subdivided or a portion of it is assigned, the easement shall remain in force for each portion of said land, provided that if by its nature it only relates to a portion of the dominant land, it shall lapse in relation to the other portions of said land. 2. If the servient land is subdivided or a portion of it is assigned, the easement shall remain in force for each portion of said land, provided that if by its nature it only relates to a portion of the servient land, it shall lapse in relation to the other portions of said land. Section 2. Easements and Prescription. 300. Acquisitive prescription of easement. 1. An easement may be acquired by acquisitive prescription, but only where it is continuous and apparent. 2. Continuous easement refers to an easement where without human action being required, the easement has materialized only because of the location of the place, and without interruption has been, in the state of, providing a benefit to the dominant land and imposing a burden on the servient land. 3. Apparent easement refers to an easement that has become apparent and materialized through an externally visible structure or other vestige. 301. Acquisitive prescription of easement by one co-owner of dominant land. 1. If one co-owner of the dominant land acquires an easement by prescription, the other co-owners shall also acquire such easement. 2. Any interruption of prescription as against co-owners shall not be effective unless it is effected against each co-owner who is exercising the easement. 3. If there are two or more co-owners exercising the easement, prescription shall run in favor of all the co-owners notwithstanding that there is cause for the suspension of prescription against one of them. 302. Commencement of extinctive prescription of easement. The period of extinctive prescription prescribed in Article 500, suspension of completion of extinctive prescription regarding rights between spouses of this code, shall be computed in respect of a non-continuous easement, from the time when the easement was last exercised, and in the case of a continuous easement, from the time of occurrence of the event that is obstructing the exercise of the easement. 303. Interruption or suspension of extinctive prescription of easement where the dominant land is co-owned. If the dominant land belongs to two or more co-owners, interruption or suspension of prescription occurring in favor of one of them shall inure to the benefit of the other co-owners. 304. Extinctive prescription of part of easement. If the easement holder does not exercise part of the easement, that part of the easement shall be extinguished by prescription. 305. Prescriptive acquisition by occupant of servient land and estate of easements. If the occupant of the servient land fulfills the conditions for acquisitive prescription, the easement shall thereby be extinguished. If the easement holder exercises the easement within the period of occupancy required for acquisitive prescription, the servient land acquired by prescription by the occupant shall be subject to the burden of the easement. Chapter 8 Ownership and other real rights of the state, Buddhist temples, minority ethnic groups and other communities. 306. Ownership and other real rights of the state, Buddhist temples, minority ethnic groups and other communities. Ownership and other real rights of the state, Buddhist temples, minority ethnic groups and other communities shall be subject to the provisions of the Civil Code, except where otherwise provided by special law or custom. Chapter 9 Rights created by concession. 307. Rights created by concession. The provisions of the Civil Code relating to perpetual leases shall apply mutatis mutandis to land rights created by concession, within the scope of the conditions applying to such concession, except where otherwise provided by special law. Book 4 Obligations. Chapter 1 General Provisions. Section I Causes of obligation and definitions of several concepts. 308. Definition of obligation. 1. An obligation is a legal relationship that connects a particular person with a specified person by having the particular person assume a certain duty with respect to the specified person. 2. The person assuming the duty shall be called the obligor, and the person receiving the benefit of performance of such duty shall be called the obligee. 3. An obligee shall possess those rights corresponding to the duty assumed by the obligor. These rights are collectively referred to in this translation as a claim. 4 309. Causes of obligation. 1. An obligation may arise from a contract, unilateral legal act, management of affairs without mandate, unjust enrichment, tortious act, or a provision of law. 2. An obligation arising from a contract or unilateral legal act is an obligation created based on the intention of one or both parties. 3. An obligation arising from management of affairs without mandate, unjust enrichment, tortious act or provision of law is an obligation created by law. The provisions set forth in chapters 3 through 7 of this book shall apply mutatis mutandis to an obligation created by law. 310. Definition of declaration of intention. 1. A declaration of intention is an expression of intention made by a party with the intent to create the legal effect. 2. The declaration of intention shall become effective when the notice thereof reaches to the other party. 311. Definition of contract. A contract is the matching of intentions held by two or more parties to create, change or extinguish an obligation. 312. Definition of unilateral legal act. 1. A unilateral legal act is an act that creates, changes or extinguishes an obligation through the unilateral expression of an intention to dispose of property or through the exercise of a right granted by contract or provision of law. 2. The provisions set forth in Sections 2 Defective declaration of intention and validity of contract, and 4 Agency, of Chapter 2 of this book shall apply mutatis mutandis to unilateral legal acts. For while the term claim generally refers to an action or demand deriving from a legal right, in this translation it refers to any substantial right that corresponds to an obligation owed by an obligor and is vested in an obligee. 313. Types of obligations. The subject matter of an obligation may be the transfer of ownership of, or the right to possess, property or money, or to perform or not to perform a certain act. 314. obligation to deliver specific property. If the subject matter of an obligation comprises delivery of a specific property, the obligor shall preserve such property with the care of a good manager until delivery thereof. 315. Obligation to deliver property in Species 1, where the property to be delivered under an obligation is described only with reference to its class or type. If different levels of quality exist with regard to such property to be delivered, the obligor shall be obligated to deliver property of the quality that was designated by the parties. If there is no such designation of the quality of the property to be delivered, the obligor shall be obligated to deliver property of medium quality. 2. With regard to obligations to deliver property described only with reference to its class or type, where the obligor has specified the property to be delivered and has completed all acts required for delivery of that specified property, the obligor has the duty to subsequently deliver only that specified property. 316. Monetary obligation. 942. If the subject matter of an obligation comprises the payment of money, the obligor may effect payment in any desired currency. However, the obligee and the obligor may agree that the payment shall be effected by a specific currency. 943. If the specific currency that forms the subject matter of an obligation has ceased to be legal tender at the time when the obligation becomes due, the obligor may effect payment in another currency. 944. The provisions of paragraphs 1 and 2 shall apply mutatis mutandis in cases where the delivery of foreign currency forms the subject matter of the obligation. 317. Monetary obligation in foreign currency. Even if the amount of an obligation is established in a foreign currency, the obligor may effect payment in Cambodian currency based on the foreign exchange rate at the place where the obligation is performed, when it becomes due. However, if the obligee and the obligor agree otherwise, such agreement shall prevail. 2. Where the obligor has delayed performing his obligation, if the obligor effects payment in Cambodian currency, the obligee may demand that the obligor calculate the amount of the payment based on the foreign exchange rate in effect when it becomes due or when the obligor effects actual payment. However, if the obligee and the obligor agree otherwise, such agreement shall prevail. 318. Legal interest rate. With respect to an interest-bearing obligation, the interest rate shall be 5% per annum, unless otherwise agreed to between the parties. 319. Interest on interest. Where the payment of interest is in arrears for 1 year or more, if the obligor fails to pay such interest after receiving a demand of payment from the obligee may include the amount of such interest in the principal. 320. Alternative obligation. If the subject matter of an obligation is to be determined by choosing from among 2 or more acts of performance, the right to choose shall belong to the obligor. However, the obligor may grant the right to choose to the obligee or to a third party by specific agreement. 321. Exercise of right to choose. 1. The right to choose shall be exercised by giving notice to the other party. Where the obligor is vested with the right to choose, such right shall be deemed to be exercised through the delivery of the property chosen by the obligor. Where a third party is vested with the right to choose, the right to choose shall be exercised through the giving of notice to either the obligor or the obligee. 2. The choice shall have retroactive effect from the time that the obligation arose. 322. Transfer of right to choose. 1. After an obligation becomes due, where either the obligor or the obligee holding the right to choose receives a demand from the other party instructing the right holder to make a choice within a reasonable fixed period of time but fails to make a choice within such period, the right to choose shall be deemed transferred to the other party. 2. Where the right to choose is vested with a third party, if the third party receives a notice from the obligor or the obligee instructing the third party to make a choice within a reasonable fixed period of time but fails to make a choice within such period, the right to choose shall be deemed transferred to the obligor. 323. Determination of irregular obligation when performance impossible. 2. Where the obligor has delayed performing his obligation, if the obligor effects payment in Cambodian currency, the obligee may demand that the obligor calculate the amount of the payment based on the foreign exchange rate in effect when it becomes due or when the obligor effects actual payment. However, if the obligee and the obligor agree otherwise, such agreement shall prevail. 318. Legal interest rate with respect to an interest-bearing obligation. The interest rate shall be 5% per annum, unless otherwise agreed to between the parties. 319. Interest on interest where the payment of interest is in arrears for 1 year or more, if the obligor fails to pay such interest after receiving a demand of payment from the obligee may include the amount of such interest in the principal. 320. Alternative obligation. If the subject matter of an obligation is to be determined by choosing from among 2 or more acts of performance, the right to choose shall belong to the obligor. However, the obligor may grant the right to choose to the obligee or to a third party by specific agreement. 321. Exercise of right to choose. 1. The right to choose shall be exercised by giving notice to the other party. Where the obligor is vested with the right to choose, such right shall be deemed to be exercised through the delivery of the property chosen by the obligor. Where a third party is vested with the right to choose, the right to choose shall be exercised through the giving of notice to either the obligor or the obligee. 2. The choice shall have retroactive effect from the time that the obligation arose. 322. Transfer of right to choose. 1. After an obligation becomes due, where either the obligor or the obligee holding the right to choose receives a demand from the other party instructing the right holder to make a choice within a reasonable fixed period of time but fails to make a choice within such period, the right to choose shall be deemed transferred to the other party. 2. Where the right to choose is vested with a third party, if the third party receives a notice from the obligor or the obligee instructing the third party to make a choice within a reasonable fixed period of time but fails to make a choice within such period, the right to choose shall be deemed transferred to the obligor. 323. Determination of irregular obligation when performance impossible. 1. If one of the acts of performance which is subject to a choice by the obligor has become impossible not due to either party on or after the date of formation, the subject matter of the obligation shall comprise the remaining acts of performance. In this case, paragraph 2 of Article 321 shall apply mutatis mutandis. 2. If an act of performance has become impossible due to the fault of the party who does not hold the right to choose, the right to choose shall be transferred to the other party. 3. If any act of performance has become impossible due to the fault of an obligor who does not hold the right to choose, the party who holds the right to choose may choose the act of performance that was rendered impossible and demand compensation for the damages from the obligor. 4. If any act of performance has become impossible due to the fault of the obligee who does not hold the right to choose, the obligor who hold the right to choose may choose the act of performance that was rendered impossible and be released from the obligation. 324. Obligation with the plurality of parties. 1. Where there are several obligee for one obligation, unless otherwise is agreed by such obligees, each of them shall have a right to the obligation in an equal proportion. 2. Where the performance of an obligation is indivisible by its nature or by declaration of intentions by the parties, if there are several obligees for the obligation, each obligee may demand performance on behalf of all the obligees and the obligor may effect performance to any obligee on behalf of all the obligees. 3. With regard to the obligation prescribed in paragraph 2, the act by or circumstances occurred to an obligees of an indivisible obligation may not be effective to other obligees. In cases where the obligor has renewed the contract with, or been exempted from the performance for one of the obligees of an indivisible obligation, if the obligor has performed part or the whole obligation upon claims by other obligees, the obligor may seek compensation from the above-mentioned obligee for the benefit which may be distributed to such obligee if such obligee has not lost its right to the obligation. 4. Where there are multiple obligees for an obligation or joint obligation exists, the provisions of Article 921, definition of joint obligation, through 937, indivisible obligation, sham obligation, divisible obligation, shall be followed. Section 3. Conditions, time and period. Subsection I. Conditions. 325. Meaning of conditions. 1. The contracting party may impose conditions with regard to the occurrence or extinguishment of the effect of the contract. With regard to a unilateral legal act, conditions may be imposed only when the conditions are not unduly detrimental to the other party. 2. Conditions are events, which occur in the future and are uncertain. 3. If an obligation or a right which arose from a contract or a unilateral legal act is subject to a condition precedent, the obligation or right shall become effective upon the fulfillment of the condition. If an obligation or a right arose from a contract or a right is subject to a condition subsequent, the obligation or contract shall cease to be effective upon the fulfillment of the condition. 326. Disposition of right subject to condition. A right that is subject to a condition may be the object of an inheritance, disposition or security interest. Furthermore, an obligation subject to a condition may be succeeded to in accordance with the provisions regarding inheritance, etc. 327. Impairment of pending benefit. 1. Neither party to an obligation subject to a condition may, while such condition is pending, impair the benefits that the other party stands to receive if the condition is fulfilled. 2. Where a third party impairs the benefits mentioned in paragraph 1, if such third party's act constitutes a tortious act, the third party shall be liable for damages. 328. Constructive fulfillment of conditions. If a party for whom the fulfillment of a condition would be detrimental intentionally obstructs the fulfillment of such condition, the other party may treat the condition as having been fulfilled. Subsection 2. Time. 329. Meaning of time. 1. If an effect of a contract is subject to a commencement time, the contract does not come into effect until such time has arrived. If a performance of a contract is subject to a commencement time, the obligee may not require the obligor to perform the obligation before such time has arrived. 2. If an effect of a contract is subject to a termination time, it shall be ceased when such time arrives. 3. With regard to an unilateral legal act, a commencement time stipulated in paragraph 1, or a termination time stipulated in paragraph may be imposed, unless it is not unduly detrimental to the other party. 330. Benefit of the determination of time. 1. Time is presumed to be stipulated for the benefit of the obligor. 2. The benefit of the determination of time may be waived, provided that it is not unduly detrimental to the other party. However, if the other party suffered damages due to the waiver, the waiving party shall be liable for such damages. 331. Forfeiture of benefit of time. The obligor shall lose the benefit of time in the following cases: a. Where the obligor has been declared bankrupt; b. Where the obligor has destroyed or diminished the security; c. Where the obligor has failed to furnish the security that the obligor was bound to furnish; or d. Where an event that was agreed upon between the parties has occurred. Subsection 2. Period. 332. Designation of period. A period may be designated in terms of hours, minutes or seconds, or in terms of days, weeks, months or years. 333. Calculation of period established in terms of seconds, minutes or hours. If a period has been fixed in terms of hours, minutes or seconds, it shall be computed from the first moment to the last moment. 334. Calculation of period established in terms of days, weeks, months or years. 1. If a period has been established in terms of days, weeks, months or years, the first day of such period shall not be included in the computation, provided, however, that this shall not apply if the period begins at midnight. 2. In cases mentioned in paragraph 1, the period shall terminate at the end of the last day of the period. 3. If the last day of a period falls on a national holiday, Sunday or any other holiday established by laws or ordinances, the period shall terminate at the end of the immediately following business day. 335. Calculation of period by solar calendar. If a period has been established in terms of weeks, months or years, it shall be computed in accordance with the calendar. 2. If a period does not commence at the beginning of a week, month or year, such period shall terminate on the day in the last week, month or year preceding the day corresponding to that on which it commenced. However, if the period has been fixed in terms of months or years and there is no corresponding day in the last month or year, the last day of the month shall be the day of termination. Chapter 2 Declaration of Intention and Contract Section I Formation of Contract 336. Formation of Contract by Offer and Acceptance 1. A contract comes into effect when an offer and an acceptance thereof conform to each other. 2. Notwithstanding the provisions of paragraph 1, a contract in which one of the parties bears a duty to transfer or to acquire ownership on an immovable, shall come into effect only when such contract is made by notarial document. 337. Definition of Offer and Acceptance 1. An offer is an invitation to enter into a contract based on the offerer's intention to be legally bound by the other party's acceptance thereof. 2. An offer shall take effect when it reaches the other party. However, an offer shall not take effect if a notice of revocation of the offer has reached the other party simultaneously with or prior to the offer. 3. An acceptance is an expression of intention by the party who receive an offer, to agree it. 4. An acceptance shall take effect when it reaches to the party who made the offer. However, an acceptance shall not take effect if a notice of revocation of the offer reaches simultaneously with or prior to the notice of acceptance. 338. Offer with acceptance period on revocation of the offer 1. An offer may be made subject to an acceptance period. An acceptance period shall, where it is unclear whether the offerer set another date, be computed from the day of dispatch of the offer. 2. An offer that specifies an acceptance period cannot be revoked. 3. If the offerer does not receive notice of acceptance within the acceptance period described in paragraph 1, the offer shall automatically lapse upon the expiration of the acceptance period. The offer shall also lapse if a notice of refusal from the other party reaches the offerer, even where such notice is received within the specified acceptance period. 1. Offer with no acceptance period and revocation of the offer 1. An offer that states no acceptance period and is made inter presens where the offeree can respond at once shall lapse unless it is accepted forthwith by the offeree. 2. An offer that states no acceptance period and is made inter absens cannot be revoked by the offerer within a reasonable period of time. 3. A revocation of an offer shall not take effect unless notice thereof reaches the offeree, prior to the offeree's dispatch of a notice of acceptance. 340. Formation of Contract on receipt of acceptance. A contract shall be formed when the notice of acceptance is received by the offerer. 341. Delayed Acceptance 1. Where cases a notice of acceptance of the offer that states an acceptance period reaches the other party after the expiration of the acceptance period, if the offerer could realize that the notice of acceptance was dispatched within the term which the notice of acceptance could reach within the acceptance period. In usual cases, the offerer must dispatch a notice of delayed acceptance to the offerer without delay. If the offerer fails to dispatch such notice, the delayed acceptance deemed to be effective. 2. The offerer can regard the notice of acceptance which reached the offerer after the acceptance period as a new offer. 342. Acceptance of Offer with Modification 1. The acceptance, to which the acceptor attaches any condition or any other substantial modification, shall not be vaid, but such purported acceptance shall be a new offer. A contract shall be formed when the original offerer accepts such new offer. 2. If the condition or modification attached to the acceptance does not substantially change the original offer, unless the offerer raises an objection immediately, the acceptance is deemed valid. The contents of the contract shall incorporate the condition or modification contained in the intended acceptance unless the offerer raises an objection immediately. 343. Formation of Contract by acts recognized as acceptance. In the event that a notice of acceptance is not required under the intention of the offerer or under applicable trade customs, the contract shall be formed when the act that is recognized as an acceptance is performed. 344. revocation of offer made to unspecified party. An offer made to unspecified parties made through advertising or other method may be revoked only using the same method employed to make the offer. Section 2. Defective declaration of intention and validity of contract. 345. Defective declaration of intention. In the following cases, a person who declares the intention may rescind the contract as the declaration of intention is defective pursuant to provisions set forth in this Section 2, defective declaration of intention and validity of contract, and 3. Invalidity and rescission. A. Where the declaration of intention is made as a result of mistake. B. Where the declaration of intention is made as a result of the other party's fraud, duress or misrepresentation. Or C. Where the declaration of intention is made as a result of the other party's act that aims to obtain excessive profits and exploits the surrounding situation. 346. Mistake 1. Where a party makes a mistake on the substantial terms of the contract, if the other party could have been aware of such mistake, the aggrieving party may rescind the contract on the ground of the defect of the declaration of intention. 2. Where a party makes a mistake on a term of the contract that such party deems important or important for the formation of the contract, if the other party could have been aware of the importance of such term and the mistake of the aggrieving party, such party may rescind the contract on the ground of the defect of the declaration of intention. 3. Where both parties makes a mistake on the substantial terms of the contract that both parties deem important to or important for the formation of the contract, each party may rescind the contract on the ground of the defect of the declaration of intention, although a party could not be aware of such mistake of the party. 4. The rescission of the contract on the ground of mistake may be asserted against a third party other than the other party. However, the rescission may not be asserted against third party if the third party acts in good faith without negligence. 347. Fraud. A person who makes a declaration of intention because of the fraud of the other party, the person may rescind the contract on the ground of the defect of the declaration of intention. 2. If a party made a declaration of intention because of the fraud of a third party, such party may rescind the contract on the ground of the defect of the declaration of intention, only if the other party knew or could have known of the fraudulent conduct. 3. A rescission of a contract on the ground of the fraud may be asserted against the third party other than the other party. However, if the third party has acted in good faith and without negligence, the rescission of the contract may not be asserted against such party. 348. Misrepresentation. 1. Where a fact asserted by a party in the course of the formation of the contract is not true and the other party made a declaration of intention based on the asserted fact, but if such party had known that such fact was not true, such party would not have made a declaration of intention, such party may rescind the contract on the ground of the defect of the declaration. 2. The provisions of paragraph 1 above do not preclude the party who made a declaration of intention from claiming the compensation for damages from the person who made the misrepresentation if such person committed a mistake. 3. The rescission of the contract on the ground of misrepresentation may be asserted against a third party other than the other party. However, if the third party has acted in good faith and without negligence, the rescission of the contract may be asserted against such party. 349. Abuse of circumstances. 1. If, in the course of the formation of a contract, a contracting party used his, her economic or social position that is better than the other party or used other circumstances so that the other party cannot contest, the other party may rescind the contract on the ground of the defect of the declaration of intention. 2. The rescission of the contract set forth in the provisions of paragraph 2 may not be asserted against a third party who has acted in good faith and without negligence. 350. Duress. A person who makes a declaration of intention because of duress exerted by the other party or a third party may rescind the contract on the ground of the defect of the declaration of intention. 351. Act of making excessive benefits. 1. If a party enters into a contract while taking advantage of the other party's economic difficulties, ignorance or inexperience, and made excessive benefits from that contract, the other party may rescind the contract on the ground of the defect of the declaration of intention. 352. Mental reservation 1. If a contract is formed by the declaration of intention made by the party who knows that it does not reflect the true intention of the declarant, the contract shall not be void. However, if the other party is aware also that such declaration of intention does not reflect the true intention of the declarant may reject the performance of the contract. 2. The provisions of Article 363 Extinctive Prescription of Right of Rescission of this Code shall also apply to the right to reject the performance of the contract set forth in the paragraph 1 above. 353. Fictitious Declaration of Intention 1. A contract formed by fictitious declaration of intention made in collusion with the other party shall be void. 2. The nullity of the contract set forth in paragraph 1 cannot be asserted against a third party that has interests in the contract based on the fictitious declaration of intention. However, this provision shall not apply if the third party was unaware of the fictitious declaration of intention in malice or by gross negligence if a part of a contract violates a mandatory provision of law or public order and good customs and if the remainder of the contract would not affect the reasonable expectations of the parties, only the part of the contract in violation of provision of law or public order and good customs shall be void. 354. Contract in violation of laws or public order and good morals 1. Even where the declarations of intention of both parties are made without any defects, the contract shall be void in the following cases: a. Where the contents of the contract violate a mandatory provision of law, or b. Where the contents of the contract contravene the public order and good customs. 2. If a part of a contract violates a mandatory provision of law or public order and good customs and if the remainder of the contract would not affect the reasonable expectations of the parties, only the part of the contract in violation of provision of law or public order and good customs shall be void. 355. Initial impossibility. Even where it was impossible to implement the content of a contract at the time of its formation, the contract shall not be void because of impossibility. However, this provision shall not preclude either contracting party to the contract from rescinding the contract on the ground of mistake if the requirements for mistake are met. 2. In case a party could have known that the content of the contract was impossible at inception and the other party suffered any damages due to the formation of the contract, the first party shall be liable for damages of the other party in accordance with the provisions of Article 398 Requirements for Damages. Section 3. Invalidity and Rescission 356. Definition of act and act in Section 3. Nullity and rescission shall mean a contract or an unilateral legal act. 357. Definition of nullity. Any person may assert the nullity of the act where the contents of the act are not consistent with the mandatory provisions of law, public order and good customs. Any person may assert the nullity of the act where the act is not consistent with the forms required by this law or other laws. 358. Voidable Act 1. A voidable act is still effective until the person having a right of rescission exercise it. 2. Where a person having a right of rescission rescind the voidable act, the act deemed void from the beginning. 3. Where the person having a right of rescission ratifies the voidable act, the act is definitively deemed valid. 359. A person having a right of rescission 1. Where an act is voidable on the ground of a defective declaration of intention set forth from Article 346 mistake to 351 conduct resulting in excessive benefits of this code, the rescission may be effected by the person who made the defective declaration of intention, his legal representative or by his curator. His heir or the person who has succeeded him in the contract may also exercise the right of rescission. 2. A rescission of an act based on incapacity or minority or other limitation on the capacity to act may be carried out by the person concerned or by his legal representative. The heir or general legatee of such person may also exercise the right of rescission. 360. Method of rescission or ratification. Where the other party to a voidable act is identified, the rescission or ratification shall be carried out with notification to the other party. The rescission or ratification shall be effectuated when the notification thereof reaches the other party. 361. Ratifying persons. Conditions of ratification. 1. Ratification of a voidable act may be carried out by a person having a right of rescission. However, where the rescission of act which was based on a defective declaration of intention, the ratification may be carried out after the person having a right of rescission learns of the cause of rescission, and where the rescission was based on an act performed by an incompetent person, the ratification may be carried out after the circumstances giving rise to the rescission no longer exist. 2. The proviso to paragraph 1 shall not apply where the ratification is carried out by the legal representative of an incompetent person or the curator. 362. Constructive ratification. A voidable act shall be deemed ratified where any of the following facts occurs after the time that ratification may be carried out pursuant to the provisions of Article 361. Ratifying persons. Conditions of ratification. A. Full or partial performance of an obligation arising due to a voidable act or the giving of security for such obligation. B. The exercise of a right obtained through a voidable act or a demand for performance by the other party, or C. A total or partial transfer or other disposition of a right obtained through a voidable act. However, this shall not apply where it is specifically stated at the time such fact occurs that ratification shall not be carried out. 363. Extinctive prescription of right of rescission. 1. A right of rescission, as well as the right to demand the return of unjust enrichment that accompanies the exercise of a right of rescission, shall be extinguished if it is not exercised within 3 years of the date on which ratification may be performed. The provisions regarding interruption of prescriptions shall not apply to this period. 2. Notwithstanding the provisions of paragraph 1, a right of rescission shall be extinguished upon the expiration of 10 years from the date of the act subject to rescission. Where multiple persons have a right of rescission regarding the same act, the provisions of paragraphs 1 and 2 above shall apply to each such person's right of rescission. Section 4. Agency. 364. Definition of agency. Agency is defined as a relationship where a representative enters into a contract with another party by stating that he is acting on behalf of a principal within the scope of the agency authorization. The effects of the contract are imputed directly to the principal. 365. Creation of agency authorization. An agency authorization can be created by contract between the principal and the agent or by law. 366. Scope of agency authorization. 1. The scope of an agency authorization is established in the contract that confers the agency authorization on the agent. Where an agency authorization is established by law, the scope of the agency authorization is established by the provisions of such law. 2. Where there is no provision regarding the scope of the agency authorization, an agent is entitled to conduct acts to preserve or improve the thing or right comprising the subject matter of the agency. However, this shall not apply to acts of improvement that would alter the nature of such thing or right. 367. Limitations on agency authorization. 1. An agent is not entitled to conduct acts with respect to which the interests of the principal conflict with the interests of the agent, even where such acts are otherwise within the scope of the agency authorization. However, this shall not apply where the principal consents thereto. 2. Dealings between the agent and the principal are presumed to involve conflicting interests between the principal and the agent. 3. Where an agent represents both the principal and a third party, paragraphs 1 and 2 shall apply mutatis mutandis to acts that give rise to conflicting interests between the principal and the third party. 368. Grounds for extinction of agency authorization. 1. An agency authorization conferred by a principal via contract is extinguished by any of the following: A. The death, bankruptcy or dissolution of the principal, B. The death or bankruptcy of the agent, or a restriction on the agent's capacity to act, or the termination of the trust, employment or other legal relationship that gave rise to the agency authorization. 2. An agency created by law is extinguished for reasons specified by law. 369. Agency without authorization: one where a person conducts an act as agent for another without having an agency authorization. The effects of that act shall not be attributable to the putative principal. However, this provision shall not apply where the act is ratified by the putative principal. 2. The other party. The act of the agency without authorization cannot assert that the act shall be effective with the agent without authorization, but this provision shall not prevent the other party from exercising his rights to require the agent without authorization to be responsible based on the provisions of Article 371. Liability of person action without agency authorization. 370. Ratification of act performed without agency authorization, and right of rescission of the other party. 1. The effect of ratification cannot be asserted against the other party unless such ratification is exercised against the other party. 2. An act conducted without agency authorization that is subsequently ratified is valid retroactively from the time it is conducted. However, where rights accrue to a third party between the time that act is conducted and the time of ratification, such rights may not be infringed. 3. The other party to an act conducted without agency authorization may demand that the putative principal indicate within a reasonable period of time designated by the other party whether the putative principal ratifies such act. If the putative principal does not respond within the established period of time, ratification shall be deemed to have been rejected. 4. The other party to a contract executed without agency authorization may rescind the contract until it is ratified by the putative principal. A putative principal may not ratify an act conducted without agency authorization after rescission by the other party. 371. Liability of person acting without agency authorization: where a person who executes a contract as agent for another cannot establish the existence of an agency authorization or obtain ratification from the putative principal, such person is liable for either performing under the contract or paying damages, at the selection of the other party. However, where the other party knew of the lack of an agency authorization when the contract was formed, the person acting without agency authorization shall be exempted from such liability. Where the person acting without agency authorization acted without negligence in regard to the absence of agency authorization, and the other party's ignorance of the lack of agency authorization was due to negligence, such person shall not be liable under the provisions of this article. 372. Agency by estoppel: 1. Where an agent executes a contract outside the scope of the agency authorization, and the other party believed without negligence that the agent was authorized to enter into the contract, the principal is responsible for performing the contract. 2. Where, after the extinction of an agency authorization, the former agent enters into a contract with another party as the agent of the former principal, the former principal is responsible for performing the contract. However, this shall not apply where the other party knew of the extinction of the agency authorization, or where the other party's ignorance of such extinction was due to the other party's negligence. 3. Where, despite the absence of an agency authorization, a putative principal gives the impression that an agency authorization has been conferred on another, or allows another person to give the impression that he has received an agency authorization, the putative principal is obligated to the other party to make performance under the contract. However, this provision shall not apply where the other party knew the absence of an agency authorization, or where the other party's ignorance of the absence of agency authorization was due to other party's negligence. 373. Anonymous acts of agency: 1. where an agent engages in a transaction with the intent of acting on behalf of a principal without disclosing such intent, the other party can treat the contract as executed between such party and the agent. However, where the other party knew, when the contract was executed, that the agent was acting on behalf of the principal, the other party can treat the contract as executed only between such party and the principal. 2. The other party can treat the contract as executed between such party and the principal where such party know the existence of the principal, after engaged in a transaction with the agency without disclosing the intention of acting on behalf of a principal. 374. Defective act of agency. 1. Where the validity of contract made by the person who makes declaration of intention may be affected on the grounds of mistake, fraud, or duress, or the knowledge or negligent ignorance of any fact by mistake, the existence or inexistence of that fact shall be determined with respect to the agent. When applying the provision of paragraph 1, where the principal has authorized the agent to execute a particular contract, the principal cannot assert the agent's ignorance of facts if they were known to the principal. This provision shall also apply in case the principal was ignorant due to the principal's negligence. 375. Capacity of agent. A principal can confer an agency authorization on a person who has a limited capacity to engage in legal acts. In this case, a contract executed between an agent having a limited capacity to act and another party cannot be rescinded by the principal on account of the agent's limited capacity. 376. Subagency. A person authorized as an agent pursuant to a contract with the principal may not appoint the subagent. However, this shall not apply where the principal consents or circumstances exist that make such subagency unavoidable. 377. Liability of agent. Where subagent has been appointed. 1. Where an agent appoints a subagent in the circumstances described in the second sentence of Article 376. Subagency. The agent is responsible to the principal in connection with the appointment and supervision of the subagent. 2. Where an agent appoints a subagent on the instructions of the principal, the agent is not responsible for the conduct of the subagent unless the agent knew that the subagent was unfit or untrustworthy and the agent failed to either notify the principal of such fact or remove the subagent. 3. Where an agent appoints a subagent under circumstances other than those described in Article 376. Subagency. The acts of the subagent shall not be imputed to the principal. However, where the other party, to a contract entered into by the subagent, is unaware of the subagent's lack of authority, and such lack of knowledge is not the result of his negligence, the other party may demand that the agent perform, under the contract, or pay damages. 378. Status of subagent. 1. An act that is conducted by a subagent within the subagent's authority and is accompanied by the subagent's express statement that the act is conducted on behalf of the principal is binding on the principal. 2. A subagent has the same rights and obligations as an agent with respect to the principal. The provisions of this section 4 shall apply mutatis mutandis to the relationships between a principal and a subagent, who shall be deemed an agent for purposes hereof. Section V. Contract for the benefit of a third party. 379. Definition. 1. The parties to a contract can agree to confer a right or benefit arising under the contract upon a third party. In this case, the person who is to perform a duty under the contract for the third party is termed the contract owner, and the other party to the contract is termed the contract owner. The person to receive the right or benefit is termed a third-party beneficiary. 2. A third-party beneficiary is entitled to make a direct demand on the contract owner for performance. 380. Third-party beneficiary. In the course of the formation of the contract, the third-party beneficiary need not exist when the requirements identifying the third-party beneficiary are clearly stated. However, where a third-party beneficiary does not exist at the scheduled time for performance of the duty by the contract owner, the promise to perform the contract for the benefit of a third party shall lose its effect. and the contract owner may be discharged from the responsibility upon performance of the contract with respect to the contract owned. 381. Declaration of intention to receive a benefit. 1. A contract owner may, at any time prior to an intended third-party beneficiary's declaration of intention to accept the benefit to the contract owner or the contract owner, withdraw the promise to perform the contract for the benefit of a third party via a notification to the contract owner and the third-party beneficiary. 2. After the third-party beneficiary declares an intention to accept their right or benefit, the parties to the contract may not thereafter alter or extinguish the third-party beneficiary's right. 382. Defense of contract owner. A contract owner under a contract to confer a right or benefit on a third party may assert against the third-party beneficiary any defenses arising under the contract. 383. Invalidity, rescission or termination of contract. 1. Where grounds for invalidity or rescission of the contract exist between the contract owner and contract owner, either party may assert the invalidity of or seek to rescind the contract in accordance with the provisions of Section 3 or Chapter 2 of this book concerning invalidity and rescission, notwithstanding the existence of a provision in the contract conferring a right or benefit on a third party. 2. A contract owner may terminate the contract on the ground of the contract owner's breach thereof. Where the contract owner's breach is grounds for termination, and the third-party beneficiary has already declared an intention to accept their right or benefit, the contract owner can terminate the contract only with the consent of the third-party beneficiary. Chapter 3 Performance of Contract. 384. Obliger's duty to perform. Obligation 1. An obligor shall perform its contractual obligations in accordance with the purpose of the contract and the principle of good faith. 2. The obligation of a party is extinguished by a performance that complies with the standard established in paragraph 1. 385. Right to demand performance of obligation. 1. An obligee is entitled to demand that the obligor perform the obligation either with or without filing a lawsuit. 2. Notwithstanding the provisions of paragraph 1, an obligee may not file a lawsuit demanding performance where the parties to the contract have agreed not to seek judicial enforcement of performance. 3. Even where a lawsuit seeking judicial enforcement of performance is barred under paragraph 2, if the obligor carries out such performance voluntarily, the obligee may receive and retain the benefits thereof. 386. Defense of simultaneous performance. Each party to a bilateral contract may refuse to perform its own obligation until the other party tenders the performance of its obligation. However, this shall not apply where the time for performance of the other party's obligation has not arrived. 387. Defense of insecurity. A party to a bilateral contract who is required to perform an obligation in advance of the other party may refuse to perform the obligation if there is a significant risk that the other party will not substantially perform its obligation in accordance with its intended purpose. However, this shall not apply where the other party provides security or otherwise takes a measure that extinguishes the existing risk. 388. Application of provisions relating to performance as a ground for extinction of obligation. In addition to the provisions of this Chapter 3, the provisions of Section 1 of Chapter 7 of this book regarding performance as a ground for extinction of obligation shall also apply to performance of contract. Chapter 4 Remedies for breach of contract. Section I General rules concerning non-performance. 389. Definition and types of non-performance. Non-performance is defined as an obligor's failure to perform an obligation arising under a contract. The types of non-performance are as follows. A. Cases in which performance cannot be carried out by the established time for performance due to a delay in performance. B. Cases in which performance is impossible. C. Cases in which full and complete performance in accordance with the intended purpose of the obligation is not carried out, and D. Other cases in which performance is not carried out in accordance with the intended purpose. 390. Remedies for non-performance. Where an obligor fails to perform an obligation, the obligee may demand specific performance, damages, or termination of the contract, in accordance with the provisions set forth in sections 2 through 4 of this chapter 4. 391. Delayed performance. An obligor shall be liable for delayed performance if he fails to perform the obligation at the time described below, a. where performance is to occur at the time certain, when such time has arrived, b. where performance is to occur at a time that is uncertain, when the obligor knows that such time has arrived, or c. where no time for performance is specified, when the obligor receives a demand for performance. 392. Impossibility of performance. 1. Where it is physically impossible to perform the obligation, the performance is deemed impossible. Performance shall also be deemed impossible where performance is determined to be impossible from a social or economic standpoint. 2. Where it is established prior to the time for performance that the performance of an obligation will be impossible at the time for performance, the performance shall be deemed impossible when such impossibility is established. 393. Incomplete performance. Incomplete performance refers to cases where an obligation has been performed but the act of performance was not complete, where only partial performance was carried out, or where for any other reason complete performance in accordance with the intended purpose of the obligation was not carried out. 394. Other non-performance. In addition to the types of non-performance described in Articles 391 delayed performance, through 393 incomplete performance, where there is a breach of any other duty arising under the contract shall be deemed non-performed. 395. Multiple remedies. Where multiple remedies are available to the obligee may select any or all of such remedies so long as they are not in mutual conflict. Section 2. Specific performance. 396. Court order for specific performance. Where an obligor does not voluntarily perform an obligation, the obligee may seek an order of specific performance from the court, except where the nature of the obligation is not suitable for specific performance. The provisions set forth in the civil enforcement law shall apply to the proceedings of specific performance. 397. Relationship to demand for performance and other remedies. Where the obligor fails to perform an obligation, the obligee may demand damages either instead of performance or together with performance so long as there is no conflict between these two demands. Section 3. Damages. 398. Requirements for damages. 1. Where an obligation is not performed, the obligee may demand damages from the obligor for any resulting harm. However, if the obligor proves that the non-performance was not the fault of the obligor is not liable for damages. 2. Where an obligor uses another person as an assistant to assist in carrying out performance of the obligation, the obligor may not avoid liability unless the obligor proves that the obligor was not negligent in the selection of and supervision over the assistant and that the assistant was not at fault. Special rules for monetary obligations. 1. Where the subject matter of the obligation is the payment of money, the obligor is not exempted from payment of interest for delay even where the obligor proves that the delay in payment was the result of force majeure. The interest for delay shall be calculated based on the legal rate of interest. Where an agreed-upon interest rate exceeds the legal interest rate, the agreed-upon interest rate shall be applied. 2. The obligor shall be exempted from liability for damages beyond interest for delay if the obligor proves that the obligor was not at fault for the non-performance. 400. Concept of damages. 1. The obligee may demand as damages, a. compensation for the benefit of performance that would have been received under the contract, as well as, b. expenditures that were wasted due to the non-performance to the extent that such expenditures do not duplicate amounts received as benefit of performance damages, and, c. additional expenditures or burdens resulting from non-performance. 2. The court may, based on a demand from the obligee, order payment of damages for mental harm. The amount of damages payable for mental harm shall be determined by the court after consideration of the surrounding circumstances. 401. Scope of damages. The obligor shall provide compensation for the following types of damages: normally occurring damages suffered by the obligee due to non-performance, Regarding special damages suffered by the obligee due to special circumstances, such damages shall be compensated, where the occurrence of such special damages could have been anticipated by the parties when the contract was executed. However, this shall not apply where the parties did not take the possible occurrence of special damages into consideration when the contract was executed, and notwithstanding subparagraphs A and B, where the non-performance is the result of the obliger's malicious intent or bad faith conduct, the court may, based on the obligee's demand for damages, order that the obligor pay to the obligee as damages the profit or benefit obtained by the obligor from the conduct comprising the non-performance. 402. Grounds for reduction of damages. 1. Where the obligee's negligence or fault contributed to the occurrence of non-performance or damages, the court may reduce the amount of damages to be paid by the obligor to the extent that the obligee's conduct contributed thereto. Where damages have been expanded due to the obligee's negligent failure to mitigate damages, the court may reduce the amount to be paid by the obligor in proportion to the amount of the damages that could have been mitigated by the obligee. 740. Liquidated damages, etc. 1. The obligor and obligee may separately and in advance establish conditions for the payment of damages and an amount to be paid. 2. A special agreement exempting the obligor from liability for non-performance that is intentional or the result of gross negligence is void. 3. Where the parties agree on the amount of damages, the court may not increase or reduce the agreed-upon amount. However, where the amount fixed by the parties as liquidated damages is either grossly higher or grossly lower than the amount of damages calculated in accordance with the provisions of Article 401 Scope of damages, the court may increase or decrease the liquidated damages amount fixed by the parties. 4. The liquidation of damages does not obstruct a claim for performance or for termination of the contract. An amount fixed and agreed to by the parties as damages for delay shall not be binding on the parties where the obligee seeks termination of the contract and compensation for damages as a substitute for the delivery of the property comprising the subject matter of the contract. 5. A penalty for breach of contract shall be presumed to constitute liquidated damages. 404. Compensation in money. Compensation for damages for non-performance shall be made by the obligor in money. However, this shall not apply where the parties separately agree otherwise. 405. Subrogation by compensation. Where an obligee has received as damages compensation for the value of the property or right comprising the subject matter of the obligation, the obligor shall be automatically subrogated to the position of the obligee in regard to that property or right. 406. Extinctive prescription. The period of extinctive prescription applicable to the right to demand compensation for damages based on non-performance is 5 years from the time when the damages occurred. Section 4. Termination of contract. Termination for non-performance. Where one of the parties to a bilateral contract commits a material breach of the contract, the other party may terminate the contract immediately. 408. Material breach of contract. 1. A material breach of contract occurs where, as a result of one party's breach of a contract, the purpose of the contract for the other party cannot be achieved, and shall be deemed to occur in any of the following situations. A. Where after a failure to perform at the specified time, the other party demands that the non-performing party perform the obligation by establishing a period of performance of reasonable length, and the obligation is not performed within such period. B. Where a party fails to perform at the specified time, and the purpose of the contract cannot be achieved if performance is not made as the specified time. C. Where it is impossible to carry out the essential act of performance, and D. Where the magnitude of the breach is so substantial that trust between the parties is destroyed and further performance cannot be expected. 2. The non-performing party may not prevent termination of the contract based on the reasons set forth in paragraph 1, on the ground that the non-performance occurred without fault on his part. 409. Method of exercise of right of termination. 1. A party having the right to terminate a contract may terminate the contract by expressing an intention to terminate to the other party. Such an intention may be expressed by means other than a lawsuit. 2. An expression of an intention to terminate may not be revoked or withdrawn. 3. An expression of an intention to terminate may be subject to a condition precedent. 410. Termination in cases of multiple parties. 1. Where one of the parties comprises multiple persons, termination of the contract must be effected by all of such persons to the other party or by the other party to all of such persons. 2. In the case described in paragraph 1, where the right of termination is extinguished as to one person, it is extinguished as to all persons. 411. Effective termination. 1. Termination of a contract relieves both parties of their duties under the contract except for the duty to pay damages. 2. Upon termination, a party that has received all or part of a performance under the contract shall return those items received as performance to the other party and return the other party to the other party's original state. Where both parties are required to return the other party to the party's original state, these duties shall be carried out simultaneously. 3. A party required to return money as a result of termination shall return the money with interest computed from the date on which the money was received. A party required to return property or other benefit due to termination shall return any benefit received thereby. 4. The legitimate interests of third parties may not be prejudiced by a termination. 412. Right of termination when subject matter is destroyed. 1. Where due to the intentional act of a person having a right of termination a thing comprising the subject matter of a contract is lost, destroyed or rendered incapable of being returned, or where such thing is changed into a thing of a different type due to processing or reworking, the right of termination shall be extinguished. 2. Where a right of termination is exercised by a person who is incapable of returning the thing in the case described in paragraph 1, the value of the thing shall be paid in money, such value not to exceed the actual price thereof, as fixed in the contract. 3. Where a thing has been destroyed or rendered incapable of being returned due to the negligence of or any other reason attributable to the other party, the person possessing a right of termination is not obligated to return the price of the thing pursuant to the provisions of paragraph 2. 413. Extinctive prescription. The period of extinctive prescription of the right of termination based on non-performance as well as the right to demand actions to return to the original state that existed prior to the execution of the contract is 5 years from the time when the non-performance occurred. 414. Agreed upon right of termination and termination by agreement. 1. The parties to a contract may agree under the contract that either one or both of the parties shall be given a right of termination. The provisions of Articles 409 Method of exercise of right of termination, through 412 Right of termination when subject matter is destroyed, pertaining to termination granted by law shall apply mutatis mutandis to the method and effect of an agreed-upon right of termination unless the parties agree otherwise. 2. Even in the absence of a contractual provision regarding a right of termination, the parties to a contract may agree to terminate the contract. However, the legitimate interests of third parties may not be prejudiced thereby. Chapter 5 Burden of Risk. 415. Extinction of obligation in case of impossibility of performance. If performance of an obligation has become impossible without the fault of the obligor, the obligation shall be extinguished and the obligee may not demand performance thereof. 416. Burden of risk in a contract to transfer title to specific property. 1. Where the subject matter of a bilateral contract is to transfer title to specific property and the property is destroyed, lost or damaged without the faults of either party, the obligor shall bear the risk thereof, and may not demand counter-performance. 2. The risk of destruction, loss or damage of the property comprising the subject matter of the contract shall be transferred to the obligee upon any of the following events unless otherwise provided for in the contract. A. When the obligor delivers the property or transfers the registration of the title thereto to the obligee, or substantial control over the property is otherwise judged to be shifted to the obligee. B. when the obligor has made a proper tender of performance, or c. when the obligee has unreasonably refused to accept the performance of the obligor. 417. Burden of risk associated with other types of rights. The provisions of Article 416 burden of risk in a contract to transfer title to specific property, shall apply mutatis mutandis to the establishment or transfer of rights in rem other than ownership, claims or other rights. 418. Burden of risk where the subject matter of contract constitutes unspecified property. 1. Where the subject matter of a bilateral contract constitutes the transfer of title to non-specific property and the property to be delivered has not yet been specified, even if the property which the obligor was preparing for a tender of performance was destroyed or lost without the fault of the obligor, the obligation shall not be extinguished, and the obligor remains obligated to perform under the contract. 2. The provisions of Article 416 burden of risk in a contract to transfer title to specific property, shall apply mutatis mutandis after the property to be delivered has been specified. 419. Contract subject to condition precedent where the property comprising the subject matter of a bilateral contract subject to a condition precedent is destroyed, lost or damaged prior to fulfillment of the condition without the fault of the obligor. The risk of such destruction, loss or damage shall be borne by the obligor. The provisions of Article 415 extinction of obligation in case of impossibility of performance, shall apply mutatis mutandis after the condition has been fulfilled. 420. Burden of risk in bilateral contract involving commission or omission of act where one of the parties to a bilateral contract has an obligation to perform or not perform a certain act and the carrying out of this obligation becomes impossible without the faults of both parties, the obligation shall be extinguished. In such a case, the obligor may not demand counter-performance. 421. Impossibility due to fault of obligee where the performance of an obligation in a bilateral contract becomes impossible without the fault of the obligor but due to the fault of the obligee, the obligor does not lose the right to demand counter-performance. However, where the obligor receives a benefit from being exempted from his obligation, he must deliver such benefit to the obligee. Chapter 6 Effect of Obligation Against Third Parties. Section I Subrogation by the Obligee. 422. Obligee's right of subrogation. 1. An obligee may, where necessary to preserve his claim, exercise a right held by the obligor in place of the obligor. However, this shall not apply to a right that is personal to the obligor, a right the exercise of which is entrusted to the complete discretion of the obligor, or a right that may not be made the subject of attachment. 2. An obligee may, where necessary to receive satisfaction of a claim held by the obligee, exercise via subrogation a right possessed by an obligor having a close connection to such claim. 423. Requirements for exercise of right of subrogation. 1. In order for an obligee to exercise the right provided for in Article 422 obligee's right of subrogation, the obligor himself may not have previously exercised such right. 2. An obligee may not exercise via subrogation a right possessed by the obligor before the obligee's own claim has ripened without the permission of the court. However, this shall not apply to an act of preservation. 424. Defense of third-party obligor. A third-party obligor facing the exercise of an obligee's right of subrogation may assert against the subrogating obligee any defenses possessed by the third-party obligor against his own obligee. 425. Relationships between subrogating obligee and obligor where the obligor is notified of the obligee's exercise of the obligor's rights via subrogation, the obligor may not exercise such rights once more against a third-party obligor. However, this shall not preclude the obligor from accepting performance made by the third-party obligor. 426. Effect of obligee's right of subrogation. 1. The effect of an obligee's exercise of a right of subrogation regarding a right held by the obligor shall inure directly to the obligor. 2. Where the obligor cannot accept performance from a third-party obligor, an obligee who exercises a right of subrogation can demand that the third-party obligor tender performance directly to the obligee. 427. Effect of exercise of right of subrogation and other obligations where performance is received by a subrogating obligee from a third-party obligor due to exercise of a right of subrogation by the obligee. The thing delivered as such performance shall be preserved for the benefit of all obligees until it is delivered to the obligor. However, this shall not apply to cases described in paragraph 2 of Article 422 Obligee's right of subrogation. Section 2. Avoidance of Fraudulent Act 428. Requirements for avoidance of fraudulent act 1. An obligee may petition the court to order that an act conducted by the obligor with the knowledge that the act would infringe on the obligee's claim be rescinded, and that a person who receives a benefit from the act of the obligor return the thing delivered or make restitution for the value thereof. 2. The rescission referred to in paragraph 1 shall be denied if the person who received the benefit from the obligor's act or a subsequent acquirer was not aware of the infringement of the obligee's claim at the time of the obligor's act or at the time of the subsequent acquisition. However, the obligee may seek rescission against the benefiting person or subsequent acquirer who paid no consideration for the benefit or the acquisition even if such person did not know of the infringement of the obligee's claim. 3. The provisions of paragraphs 1 and 2 shall not apply to acts that were not intended to acquire a property right. 5. 429. Claims to be preserved. The provisions of Article 428 requirements for avoidance of fraudulent act shall also apply to an obligee having a non-monetary claim. However, the claim must be transformed into a monetary claim by the end of oral argument proceedings on which a judgment of rescission is based. 430. Method of rescission of fraudulent act where no other appropriate method exists to achieve restitution by a person receiving a benefit from the obligor's act or a subsequent acquirer. An obligee who exercises a right of rescission may demand that the benefiting person or subsequent acquirer deposit the thing obtained with an authorized depository office. 431. Effect of rescission of fraudulent act. Rescission conducted pursuant to the provisions of Article 428 requirements for avoidance of fraudulent act shall inure to the benefit of all obligees. 432. Period for exercise of right of rescission of fraudulent act. 1. The right of rescission established in Article 428 requirements for avoidance of fraudulent act shall expire if it is not exercised within 1 year of the time that the ground for rescission is first discovered by the obligee, or within 3 years of the occurrence of the act giving rise thereto. 2. The provisions of law pertaining to interruption of a period of prescription shall not apply to the expiration period of a right of rescission as provided in paragraph 1. Chapter 7 Extinction of Obligation. 433. Grounds for extinction of obligation. Obligations shall be extinguished on the following grounds: a. By performance, set-off, release, novation or merger as provided in sections I through V of this chapter 7, b. By impossibility of performance without the fault of the obligor as provided in chapter 5 of this book, c. By the fulfillment of a condition subsequent as provided in section the 3rd of chapter 1, or by termination of the contract. 5. See the footnote to Article 195 for the explanation of property right. As provided in section the 4th of chapter 4, d. By extinctive prescription as provided in chapter 8, or e. By the exercise of a right of rescission pursuant to the provisions of section the 3rd of chapter 2. Section I. Performance. Subsection I. General provisions regarding performance. 434. Performing person. 1. An obligation may be performed by a third party as well as by the obligor. 2. If the purpose of the obligation cannot be achieved by the performance of a third party, the third party may not perform the obligation unless the obligee consents. 3. The obligor and the obligee may agree not to allow performance by a third party. 435. Authority of disposition of performing person. 1. A performance made by a person who neither owns the property delivered for the purpose of performance nor has the authority to dispose of it shall not be a valid performance. 2. Where the person making performance did not own the property delivered for the purpose of performance, He cannot recover such property until valid performance is made. However, the owner of such property may recover the property from the person receiving the invalid performance. 3. Where a person carrying out performance lacks capacity to dispose of the property delivered for the purpose of performance, such person may rescind the act of performance. Paragraph 2, shall apply mutatis mutandis to the return of the property delivered for the purpose of performance. 436. Good faith consumption, transfer or acquisition by bona fide obligee 1, in the cases described in paragraphs 2 and 3 of Article 435. Authority of disposition of performing person, where the property delivered for the purpose of performance constituted movable property and the obligee has consumed or transferred in good faith the items received as performance, such performance shall be deemed valid and the performing person may not demand the return of such property. In the case described in paragraph 1, the owner of the property delivered for the purpose of performance may demand reimbursement for such property from the receiver of performance, unless such receiver acquired ownership of the property in accordance with the provisions set forth in Article 193 bona fide acquisition of ownership of movable, regarding good faith acquisition. However, an obligee that has compensated the owner of the property delivered for the purpose of performance may demand reimbursement for such amount from the obligor. 437. Power to accept performance 1. Performance is invalid unless it is carried out for the obligee or other person authorized to receive the performance. 2. Where the obligor performs his obligation for a person who does not have power to receive performance, the obligor must perform once more for the obligee at the obligee's request. However, the person who made performance may demand that the unauthorized receiver of the performance return the property delivered for the purpose of the performance. 438. Restriction of power to accept performance 1. Where a claim held by an obligee has been subject to attachment by an order of the court, the obligee shall not have the power to accept performance made by the obligor, and the obligor may not make performance to the obligee. 2. Paragraph 2 of Article 437. Power to accept performance shall apply mutatis mutandis to the case in which an obligor that has been barred from making payment makes performance to his obligee. 439. Performance to quasi-holder of Claim 1, a performance made to a person who appears to be the obligee but who in fact is not the true obligee shall be treated as valid if the performing party believed the receiver to be the true obligee and such belief was not the result of gross negligence. 2. In cases described in paragraph 1, the true obligee may not demand that the obligor perform again. However, the true obligee may demand that the person receiving the performance return the property delivered for the purpose of the performance. 440. Manner of performance. An obligor shall perform the obligation in accordance with the purpose of the obligation and in good faith. 441. Partial performance. An obligee is not required to accept partial performance. However, where an obligee accepts a performance knowing that it is partial, the performance is effective to the extent it is accepted. Performance with substitute property 1. Where with the consent of the obligee an obligor makes a substitute act of performance that differs from the originally intended act of performance, it shall have the same effect as a valid performance. 2. An obligee and obligor can agree that a substitute act of performance be made in place of the originally intended act of performance. In such a case the obligor may choose to perform either the originally intended act of performance or the agreed substitute act of performance, except where the right to choose has been given to the obligee. 443. Time of performance. Performance before set time 1. An obligor shall perform the obligation at the time for performance as determined in each of the subparagraphs of Article 391. Delayed performance. 2. A performance may be made before it is due according to the provisions of paragraph 2 Article 330. Benefit of the determination of time. 444. Hours of performance. An obligor shall effect performance during regular business hours in accordance with prevailing customs and in good faith. 445. Place of performance. Where the place of performance is not agreed to between the parties, Performance of an obligation to deliver specific property shall be made at the place where the property was located at the time the obligation arose. For other obligations, the performance shall be made at the current residence of the obligee. 446. Costs of performance. In the absence of an agreement regarding the costs of performance, such costs shall be borne by the obligor. However, if an increase in the costs of performance is due to change in the residence of the obligee or to some other act of the obligee, such increase shall be borne by the obligee. 447. Delivery of receipt. The performing party may demand a receipt from the person accepting the performance. 448. Return of documents. If documents evidencing the obligation exist, the performing party may demand the return of such documents when the entire obligation has been performed. Subsection 2. Assignment of performance. 449. Assignment via designation. 1. Where an obligor owes to the same obligee multiple obligations of the same type, if a tender of performance is not sufficient to discharge all of the obligations, the performing party may at the time of performance designate the obligation to which the performance shall be assigned. 2. If the performing party does not make the designation described in paragraph 1, the party accepting the performance may make the assignment when performance is accepted. However, the provisions of statutory assignment shall apply if the performing party makes an immediate objection to such assignment. 3. The assignment described in paragraphs 1 and 2 shall be made via notice to the other party. 450. Statutory assignment. If neither the performing party nor the party receiving performance make an assignment of performance, the performance shall be assigned according to the following rules. A. Between the obligations that are due and those that are not due, the former shall have priority. B. Where all of the obligations are either due or not due, the obligation as to which discharge would confer the greatest benefit on the obligor shall have priority. C. If the obligor would benefit equally from the discharge of all obligations, the obligation which first became due or will become due shall have priority. D. Among multiple obligations that are equal in regard to the benefit of discharge for the obligor and that become due at the same time, the performance shall be assigned in proportion to the amount of each obligation. 451. Order of assignment among costs, interests and principal. If an obligor as to one or more obligations is obligated to pay interest and costs in addition to principal, a performance that is insufficient to discharge all of these shall be assigned in the order of costs, interest and principal. However, if the obligor and the obligee have agreed otherwise, such agreement shall prevail. 452. Performance for two or more obligees. The provisions of Articles 449 Assignment via designation, 450 Statutory assignment, and 451 Order of assignment among costs, interests and principal, shall apply mutatis mutandis where the obligor owes multiple obligations to different obligees and the obligation as to which the obligor's performance was directed cannot be determined. Subsection 2. Tender and deposit. 585. Meaning and basic effect of tender of performance. 1. Tender of performance shall mean that the obligor has completed preparations for an act of performance and has asked the obligee to accept such performance. 2. Even where the obligor has made a tender of performance, if an obligee does not take the actions necessary to accept the performance, the obligor is relieved of liability for non-performance. 3. Where the obligor who owes a monetary obligation with interest accruing thereon makes a tender of performance, if the obligee does not accept the performance, the obligor shall subsequently not be required to pay interest thereon. 454. Method of tender. A tender of performance must constitute an actual tender of performance in accordance with the intended purpose of the obligation. However, where the obligee has refused in advance to accept the tender of performance, or an act on the part of the obligee is necessary for performance of the obligation, it is sufficient for the obligor to give notice to the obligee that preparations for performance have been completed and demand the obligee's acceptance of performance. 455. Effect of tender. Where an obligee does not accept a tender of performance, the following effects shall occur, in addition to the effect described in Article 453 meaning and basic effect of tender of performance. A. Where the obligor bears the risk in a bilateral contract, the risk shall be transferred to the obligee. B. The obligee shall lose the defense of simultaneous performance in a bilateral contract. And C. The obligor may be exempted from the obligation by carrying out deposit. 456. Delayed receipt 746. Where the obligee has in advance refused to accept performance, or where tender of performance has been made to the obligee, if performance is not accepted due to the obligee's fault, the obligor may demand damages from the obligee for any injury caused by such non-acceptance. 747. Where the obligee's non-acceptance of a tender of performance constitutes a material breach of the obligee's contractual duties, the obligor may terminate the contract. Deposit 1. An obligor may discharge the obligation by depositing the property comprising the subject matter of the obligation with an authorized depository office in the following situations: A. Where the performing party has made a tender of performance, but the obligee refuses to accept or cannot accept the performance, or B. Where the identity of the obligee cannot be determined without any fault of the obligor. 2. The performing party may recover the property deposited until the obligee has accepted the deposit or a judgment declaring the deposit valid has become final and binding. In such a case, the deposit shall be deemed not to have occurred. However, this shall not apply where a pledge or hypothec has been extinguished as a result of the deposit. 3. The details and procedures governing deposit shall be prescribed in the Official Deposit Act. 458. Obligor's right to sell if the property comprising the subject matter of the obligation is not suitable for official deposit, or is in danger of perishing or being damaged. The obligor may, with the permission of the court, sell the property via public auction and deposit the proceeds with an authorized depository office. The same applies where the cost of preserving the property is prohibitive. Subsection 3. Subrogation by performance 459. Subrogation by performance 1. A person who has procured a discharge through his own performance or other expenditure and thereby obtains the right to demand indemnification from the obligor may exercise via subrogation the claim held by the obligee and all other rights associated therewith. 2. The provisions of Article 503 requirement for assertion of assignment of nominative claim against third parties shall apply mutatis mutandis to the situation described in paragraph 1. 3. The notification described in Articles 913 requirements for indemnification, and 933 notification as requirement for indemnification, may be substituted for the notification described in paragraph 2. However, where a date-certified instrument is demanded in connection with provisions as to which paragraph 2 hereof applies mutatis mutandis, the notification described in this paragraph shall also be provided by means of a date-certified instrument. 460. Scope of subrogation, relationships among subrogatees 1. A person who has been subrogated to the position of an obligee through the operation of Article 459 subrogation by performance, may exercise, within the scope of indemnification that can be demanded based on his own right, any and all rights that were possessed by the obligee by virtue of the automatic effect of the principal claim or that derive from a security interest. However, this shall not apply to rights that directly accompany the contractual position of the obligee under the contract. 2. The following conditions shall apply to a subrogee: A. Unless the existence of a subrogation is honored in the registration of a statutory lien, pledge of a movable or hypothec that is created over any of the obligor's property, a guarantor or a third-party security provider cannot assert his subrogation to the position of an obligee against a third-party acquirer who acquires an immovable comprising the object of such statutory lien, pledge or hypothec. B. A third-party acquirer who acquires a thing comprising the object of any security interest from an obligor shall not be subrogated to the position of an obligee with respect to a guarantor. C. A third-party acquirer who acquires a thing comprising the object of any security interest from an obligor shall be subrogated to the position of an obligee with respect to other third-party acquirers who acquire the objects of other security interests from such obligor in proportion to the respective values of the acquired things. D. The provisions of subparagraph C shall apply mutatis mutandis to the relationships between third-party security providers as described in Article 758.A.766 Definition of security provider and third-party acquirer. E. As between guarantors and third-party security providers, subrogation to the position of the obligee shall be made in accordance with the number of persons of each group. However, where there are multiple third-party security providers, subrogation to the position of the obligee shall be made in accordance with the respective prices of the things provided for security by each third-party security provider with regard to the portion of the obligation remaining after subtracting the portion for which a group of guarantors is responsible. 461. Partial subrogation. 1. Where subrogated performance of a part of an obligation has been made, a subrogee shall exercise the rights of the obligee together with the obligee to the extent of the partial performance. However, where the subrogee seeks to execute these rights, the obligee's consent must be obtained. Furthermore, at the request of the obligee, such rights or ranking shall be transferred to the obligee at no cost to the extent of the remaining obligation. In the case described in paragraph 1, only the obligee may terminate the contract on the ground of non-performance. However, the subrogee shall be compensated to the extent of the subrogee's performance and interest thereon. 462. Subrogated performance by a third party and certificate of claim, object of security. 1. An obligee who has received full performance via subrogated performance shall deliver to the subrogee a certificate of claim and any object of security possessed by the obligee. 2. Where subrogated performance has been made with respect to a portion of the claim, the obligee shall indicate on the claim instrument that subrogation has been carried out and shall ensure that the subrogee supervises the preservation of the object of security possessed by the obligee. 463. Obligation to preserve security for benefit of subrogee. Where a person exists who could be subrogated to the position of an obligee pursuant to the provisions of Article 459 subrogation by performance, and the security has been lost or diminished due to the intentional or negligent act of the obligee, a person qualified to invoke such subrogation may be exempted from his own responsibility or seek damages to the extent that such person is no longer able to receive indemnification due to such loss or diminution. Section 2. Set-off. 464. Conditions of statutory set-off and set-off contract. 1. Where two persons owe mutual obligations having the identical subject matter, if both obligations are due for performance, one party may extinguish mutual obligations to the extent that their respective amounts are equal by making a declaration of intention of set-off. 2. The parties may enter into a set-off contract to extinguish the mutual obligations even though both obligations do not have an identical subject matter. However, the right of a third party who is ignorant of such particular contract may not be infringed thereby. 465. Method of set-off. 1. A set-off shall be effected by a party's declaration to set off to the other party. 2. A declaration of intention of a set-off may be subject to a condition precedent, but it may not be subject to a condition subsequent or to a fixed time. 466. Timing of effective set-off. Where the requirements for a set-off are satisfied, if a party declares a set-off, the set-off shall have effect of retroactively extinguishing the two obligations as of the time that the obligations became suitable for a set-off. 467. Limitations on set-off. 1. If either or both of the obligations are not suitable for a set-off in light of the nature of the obligations, a set-off may not be executed. 2. If there is an agreement between the parties not to declare a set-off, neither party may declare a set-off. However, such an agreement may not be asserted against a bona fide third party. 468. Set off when the counter-obligation is subject to defense. 1. A party may not execute the set-off if the counter-obligation owed by the other party is subject to any defense exercisable by the other party. 2. An obligation as to which the period of prescription or the period for exercise has elapsed may be set off by the obligee where the requirements for a set-off are met prior to the elapsing of such period. 469. Set-off of obligation arising out of tort. An obligor who owes an obligation arising out of tort may not assert the extinction of such obligation based on a set-off. A. Obligation prohibited from being attached. Where attachment of an obligation, by the obligee's creditors, is prohibited, the obligor may not assert the extinction of such obligation based on a set-off. 471. Obligation under attachment to order. 1. Where an obligation is under an order of attachment initiated by a third party, the obligor may set off the obligation only against a counter-obligation owed by the other party and obtained prior to such attachment, and when the counter-obligation becomes due. However, this shall not apply to cases where such counter-obligation will become due later than the obligation owed and to be set off by the obligor. 2. The second sentence of paragraph 1 shall not apply if there is an agreement between the parties allowing a set-off of obligations irrespective of the time for performance thereof. 472. Assignment in case of set-off. If one or both of the parties to a set-off owe more than one obligation suitable for set-off, the party declaring a set-off may designate the obligations which are to be extinguished by the set-off. If a set-off is declared without the designation described in the first sentence of this article, the provisions regarding assignment of performance shall apply mutatis mutandis. 473. Release as unilateral legal act. An obligation is extinguished when an obligee expresses to the obligor an intention to release the obligor from the obligation. 474. Partial release. An obligee may declare a partial release from an obligation. 475. Limitation on release. If an obligation is under attachment by a third party or the power of the obligee to dispose of the obligation is restricted for any other reason, the obligee may not release the obligor from the obligation. Section 4. Novation. 476. Meaning of novation. 1. A novation shall refer to a contract that extinguishes the original obligation and creates a new obligation in its place as between the same obligee and obligor. 2. The original obligation is extinguished at the moment that the novation contract described in paragraph 1 becomes effective. 477. Non-extinction of original obligation. If an obligation created by a novation contract does not come into effect because the obligor of the original obligations cannot be expected, or if the new obligation is impossible to perform from the beginning, the original obligation is not extinguished. 478. Transfer of security right. 1. If so agreed to between the parties to the novation contract, a pledge, hypothec or other security interest established in regard to the original obligation may be transferred to a new obligation to the extent that it falls within the scope of the original obligation. However, a security interest provided by a third party shall not be transferred without the third party's consent. 2. With regard to a quasi-loan for consumption, the agreement mentioned in the first sentence of paragraph 1 shall be presumed to exist. Section V. Merger of claim and obligation. 1. Where an obligation and a claim, corresponding to such obligation, belong to one and the same person, such obligation and claim shall be extinguished via merger. 2. If the claim mentioned in paragraph 1 comprises the object of a right possessed by a third party, such claim is not extinguished by merger. Chapter 8. Extinctive prescription regarding claims. 480. Definition of extinctive prescription regarding claim. Extinctive prescription regarding a claim refers to the extinction of a claim based on an obligee's continuous failure to exercise the claim for a certain period of time. 481. Commencement of extinctive prescription period for claim. Extinctive prescription regarding a claim runs from the time that the claim is capable of being exercised. 482. Extinctive prescription period for general claim. The extinctive prescription period for claims is 5 years, except as otherwise provided in this code or in other laws or ordinances. 483. Short extinctive prescription period. The extinctive prescription period for a claim pertaining to the price of a product or service sold or provided by a manufacturer or merchant to a non-merchant is 2 years. 484. Extinctive prescription period for established claim. 1. The extinctive prescription period for a claim that is definitively established through a final and binding judgment, a judicial settlement, or other determination having the effect of a final and binding judgment shall be 5 years from the time when it is definitively established, even where a prescription period of less than 5 years is otherwise established by law. 2. The provisions of paragraph 1 shall not apply where the time for performance has not occurred as of the time that the claim is definitively established. 485. Retroactive effect of extinctive prescription regarding claim. The effect of extinctive prescription of claim is retroactive from the date of commencement of the period thereof. 486. Invocation of extinctive prescription regarding claim. A court cannot render a judgment based on extinctive prescription regarding a claim unless extinctive prescription is invoked by a party. 2. Extinctive prescription regarding a claim may be invoked only by an obligor, a joint obligor, a guarantor, a third-party security provider and a third-party acquirer as specified in Article 758.A.766. Definition of security provider and third-party acquirer, or other person possessing a legally recognized interest in the invocation of extinctive prescription. 3. Where extinctive prescription regarding a claim is invoked by an obligor, third parties shall also receive the benefit of the extinctive prescription. Where extinctive prescription regarding a claim is invoked by a person having a right to do so other than the obligor, the invocation is effective only as between such person and the obligee. 487. Renunciation of benefit of extinctive prescription regarding claim. The benefit of extinctive prescription cannot be renounced in advance. The benefit of an extinctive prescription, the period for which has already been completed, can be renounced. 488. Scope of persons to whom effective renunciation of benefit of extinctive prescription regarding claim extends. A renunciation of the benefit of extinctive prescription of a claim is effective only as between the obligee and the renouncing party having the right to invoke extinctive prescription. 489. Grounds for interruption of extinctive prescription of claims. Extinctive prescription regarding a claim is interrupted by the occurrence of any of the following events: a. Filing of a lawsuit, participation in a bankruptcy proceeding, or the equivalent exercise of a claim; b. An act of execution or issuance of a preliminary injunction, or c. Partial repayment, payment of interest, provision of security or acknowledgement of the existence of the claim by some other method. 490. Effect of interruption of extinctive prescription regarding claim. Scope of persons where extinctive prescription regarding a claim is interrupted as against an obligor. Other persons may not contest the effect of that interruption. Where extinctive prescription regarding a claim is interrupted against a person who is not the obligor and has a right to invoke extinctive prescription, the interruption is effective only between the obligee and such person entitled to invoke extinctive prescription. Lawsuit. A judicial action does not interrupt extinctive prescription where the action is dismissed without prejudice or discontinued. 492. Rescission of act of execution or preliminary injunction. Where an act of execution or preliminary injunction is rescinded upon the motion of a right holder or for failure to comply with conditions imposed by law, interruption of extinctive prescription effected by such act shall be deemed not to have occurred. 493. Act of execution or preliminary injunction conducted as against person other than obligor. An act of execution or preliminary injunction conducted as against a person other than the obligor interrupts extinctive prescription as to the obligor only where the obligor is notified of such act. 494. Running of extinctive prescription period regarding claim following interruption. 1. An extinctive prescription period that was interrupted shall begin anew from the time that the ground for interruption no longer exists. 2. An extinctive prescription period that was interrupted due to the filing of a lawsuit shall begin anew from the time that the decision resolving the lawsuit becomes final and binding. 495. Suspension of completion of extinctive prescription period upon demand with or without filing of lawsuit. 1. Where a right holder demands satisfaction of such right within 6 months of the completion of an extinctive prescription period, the extinctive prescription period is not completed as against such person until 6 months elapses after the time of the demand. However, a subsequent demand for satisfaction by the right holder shall not delay the completion of the extinctive prescription. 2. Even where a lawsuit does not have the effect of interrupting the extinctive prescription period due to the dismissal without prejudice or discontinuation of the lawsuit, a demand shall be deemed to have been provided continuously from the time the complaint was filed until the time the lawsuit was dismissed or discontinued. In this case, the extinctive prescription period is not completed as against the person who brought the lawsuit until 6 months have elapsed from the date of dismissal or discontinuation. Where the right holder asserts his right as a defendant in litigation, such assertion shall be deemed a continuous demand during the pendency of the lawsuit from the time at which it is made. In this case, the extinctive prescription period is not completed as against such person until 6 months have elapsed from the date on which the judgment in the case becomes final and binding. 496. Suspension of completion of extinctive prescription period regarding rights pertaining to minors or incompetent persons where there is no legal representative for a minor or incompetent person within 6 months prior to the completion of an extinctive prescription period. The extinctive prescription period for claims is not perfected as against such person until 6 months elapses after the time such person attains the age of majority or legal representative is retained on the person's behalf. 497. Suspension of completion of extinctive prescription regarding rights between spouses where one spouse possesses a right with respect to the other. Extinctive prescription regarding such right is not completed until 6 months elapses after the marriage is dissolved. 498. Suspension of completion of extinctive prescription due to natural disaster where a right holder is unable to interrupt extinctive prescription within 6 months prior to the completion of the extinctive prescription period due to natural disaster or other force majeure. Extinctive prescription is not completed until 6 months elapses after the time that such force majeure ceases to exist. 499. Performance in order to satisfy right subject to extinctive prescription. A person who provides a performance in order to satisfy a right subject to completed extinctive prescription may not thereafter seek repayment, even where the performance is provided without knowledge of the fact that such right was subject to completed extinctive prescription. 500. Extinctive prescription for property rights other than claims and ownership except as otherwise provided in this code or in other laws or ordinances. The period for extinctive prescription regarding property rights other than claims and ownership shall be 10 years. The provisions pertaining to extinctive prescription regarding claims shall apply mutatis mutandis to extinctive prescription for property rights other than claims and ownership. Chapter 9 Assignment of Claims and Assumption of Obligations. Section I Assignment of Claims. 501. Assignability of Claims. Special Agreement prohibiting assignment. 1. A claim may be assigned unless the nature of the claim does not permit the assignment. In such a case, the assignee shall become a new obligee. 2. Assignment of a claim can be prohibited by a manifestation of intention by the parties, even where the nature of the claim permits the assignment. 3. The manifestation of intention referred to in paragraph 2 cannot be asserted against a third party having no knowledge thereof. However, this shall not apply where the third party's lack of knowledge is the result of the third party's gross negligence. 502. Establishment of assignment of claim. The assignment of claim shall take effect only through agreement between the obligee seeking to assign the claim and the assignee. However, in order to assert the assignment of a claim against the obligor or a third party, The conditions established in Article 503 requirement for assertion of assignment of nominative claim against third parties must be met. 503. Requirement for assertion of assignment of nominative claim against third parties. 1. The assignment of a nominative claim may not be asserted against the applicable obligor or any other third party unless the assigner has given notice thereof to the obligor or the obligor has consented thereto to the assigner or the assignee. 2. The notice or consent described in paragraph 1 may not be asserted against a third party other than the obligor unless the notice or the consent is made using an instrument bearing a fixed date. 504. Priority among multiple assignments. 1. Where one claim has been assigned multiple times, the priority among such assignments shall be determined based on the chronological order of the times at which the competing notices using the instruments bearing a fixed date reach the obligor, or of the times at which the obligor gives consents using the instruments bearing a fixed date. In this case, the obligor must perform the obligation owed to the obligee having the priority position. 2. In the situation described in paragraph 1, where the chronological order among the notifications or consents cannot be clearly determined, they shall be deemed to have arrived or been given at the same time. In this case, each assignee may demand performance from the obligor for the entirety of the assigned obligation. Where the obligor performs the obligation to one obligee, the obligation is extinguished. 3. In the case described in paragraph 2, the obligor can be relieved of the obligation by making a deposit of the thing comprising the subject matter of the obligation. 505. Effect of notification and consent. 1. If the obligor has given the consent described in Article 503 requirement for assertion of assignment of nominative claim against third parties, without raising any objection, even if there are grounds which could have been raised as a defense against the assigner, he may not raise such grounds as a defense against the assignee. However, if the obligor has paid any money or delivered anything or assumed a new obligation to or for the benefit of the assigner in order to obtain extinction of her obligation, the obligor may recover the money paid or other thing delivered, or may deem that the new obligation had not been assumed, as the case may be. 2. In cases where the assigner has merely given notice of the assignment, the obligor may raise any ground as a defense against the assignee which accrues vis-à-vis the assigner before he receives such notice as a defense against the assignee. 506. Assignment of negotiable claim. The conditions governing assignment of a claim payable to order or other claim regarding which an instrument representing such claim has been issued shall be established separately by special law. Section 2. Assumption of obligations. 507. Possibility of assumption of obligation. 1. An obligation that can be performed by a third party other than the obligor can be assumed by a third party. 2. The assumption of an obligation by a third party may be prohibited through a manifestation of intention by parties. 508. Establishment of assumption of obligation. The assumption of an obligation takes effect based on agreement between the obligor and the person assuming the obligation or between the obligee and such person. 509. Rights of obligee. 1. An obligee's rights against the obligor are not extinguished by an assumption of the obligation. In this case, the obligor and the party assuming the obligation are jointly and severally responsible with respect to the obligee. A party who assumes an obligation may exempt the obligor with the consent of the obligee. 510. Defenses after obligation is assumed. Where an obligation is assumed, the assuming party may assert against the obligee any defenses possessed by the obligor up to the time that the assumption came into existence. 511. Assumption of performance. Where a person assumes responsibility for performance of an obligation based on agreement between the obligor and the assuming party without assuming the obligation itself, the obligee may not demand performance from the assuming party. Section 3. Assignment of contractual position. 512. Assignment of contractual position. 1. A person who has executed a contract with another person may assign to a third party his position under the contract. However, this shall not apply where assignment is impossible due to the nature of the contract. Moreover, assignment of a party's contractual position may be prohibited by the agreement of the parties. In this case, the provisions of paragraph 3 of Article 501 Assignability of Claims, special agreement prohibiting assignment, pertaining to assignment of obligations shall apply mutatis mutandis. 2. Where the assignment of a contractual position is substantially disadvantageous to the other party to the contract, the party seeking to assign the contractual position shall obtain the approval of the other party to the contract to the assignment. 513. Establishment of assignment of contractual position. The assignment of a contractual position shall take effect only upon the agreement of the assignee and the party to the contract who is seeking to assign the contractual position. However, in order to assert the assignment against the other party to the contract or a third party, the requirements for assertion set forth in Article 503 requirement for assertion of assignment of nominative claim against third parties, pertaining to assignment of claims must be met. 514. Effective assignment of contractual position. Where a contractual position has been assigned, all of the rights and obligations possessed by the assignor shall be transferred to the assignee unless a specific manifestation of intention is made to the contrary. In this case, the provisions of Article 505 effective notification and consent, pertaining to assignment of claims, and of Article 510 defenses after obligation is assumed, pertaining to the assumption of obligations shall apply mutatis mutandis. Book 5 Particular types of contracts, towards Chapter 1 Sale Section I General Provisions 515. Nature of sale. A sale is a contract whereby one party, called the seller, is obligated to transfer ownership or other property rights 6 to the other party, called the buyer, and the buyer is obligated to pay the purchase price to the seller. 516. Formation of sale contract. The sale contract is formed based only on the agreement of the parties thereto unless otherwise provided by law. However, the parties may require as a condition for the formation of the contract the execution of a notarial document or a written document signed by the parties in their individual capacities. 517. Unilateral promise to sell or purchase. 1. Where a promise is made with respect to either a sale or a purchase, the sale shall become effective from the time that the promisee expresses to the promisor an intention to complete the sale. 2. Where no period is fixed for the expression of intention described in paragraph 1, the promisor may issue a notification to the promisee demanding the expression of intention within a fixed period of reasonable length regarding whether the promisee intends to complete the sale. If the promisee fails to provide the expression of intention within such period, the promise shall lapse. 518. Earnest money. Where the buyer has paid earnest money to the seller, the buyer may rescind the contract by giving up his earnest money, and the seller may rescind the contract by refunding twice the amount thereof. However, neither party may rescind the contract after the other party has commenced performance thereof. 519. Sale after tasting. 1. A sale of goods 7 of a type that are customarily tested before purchase shall be formed when the prospective buyer accepts the sale after carrying out such tasting. 6. See the footnote to Article 2421 of Book 3 for the explanation of property right. See the footnote to Article 111 of Book 3 for the explanation on the usage of goods. 2. Where no period is fixed for the prospective buyer's acceptance, the seller may issue a notification to the prospective buyer demanding a definite answer within a fixed period of reasonable length regarding whether the prospective buyer accepts the sale. If the prospective buyer fails to provide an answer within such period, the prospective buyer shall be deemed to have refused to enter into the sale. 520. Trial sale. 1. A trial sale shall become effective when the prospective buyer accepts the sale within the trial period or when the trial period has lapsed without the prospective buyer's expression of any intention in regard to the sale. If the prospective buyer refuses to receive the delivery of the goods, the sale contract shall be deemed not formed. 2. Where no period is fixed for trial, the prospective seller may issue a notification to the prospective buyer demanding a definite answer within a fixed period of reasonable length regarding whether the prospective buyer accepts the sale. If the prospective buyer continues to use the goods without providing an answer within that period, the prospective buyer shall be deemed to have accepted the sale. 521. Sale price. 1. The parties to a sale shall fix under the contract the amount of the sale price or establish a formula to determine such amount. 2. The amount of the sale price may be determined in accordance with the present or future market price of certain merchandise or based on the appraisal of a third party who is appointed by a method designated by the parties. Where an appraisal by a third party is based on mistake, or where the appraisal appears to violate principles of fairness, the contract party that would be harmed as a result may object to such appraisal. 3. The parties to the contract may fix the sale price at a certain definite amount or based on indefinite or lifetime installment payments. However, where a third party is to appraise the sale price in accordance with the provisions of paragraph 2, the sale price shall be fixed as a certain definite amount, except where the parties have explicitly authorized the third party to fix the sale price based on indefinite or lifetime installment payments. 522. Sales expenses. Unless otherwise agreed to between the parties, the cost of preparing written instruments and other expenses incurred in connection with the execution of a contract of sale shall be borne equally by both parties. 523. Mutatis mutandis. Application to other types of contract in which either or both parties provide consideration. The provisions of this chapter 1 shall apply mutatis mutandis to contracts, other than sale contracts, in which either or both parties provide consideration. Section 2. Parties to and goods covered by sale contract. 524. Parties to sale contract. Any natural or juridical person may sell or purchase goods or rights, except where prohibited by law. 525. Persons who may not be buyers. 1. An administrator appointed by law, court order or contract may not be a buyer, either directly or through a third party, of goods that the administrator has been entrusted to sell. 2. Paragraph 1 shall apply mutatis mutandis to government officials responsible for the execution or administration of compulsory sale. 3. Where a sale is conducted in violation of the provisions of paragraphs 1 and 2, such sale may be rescinded only by the person who owned the goods prior to the sale or by the heir of such person or such person's successor in interest. 526. Persons who may not be buyers. 2. 1. A judge, prosecutor, court clerk or other court official may not be a buyer, either directly or through a third party, of goods or rights as to which civil actions are pending before the court at which such person works or practices. 2. Paragraph 1 shall apply mutatis mutandis to lawyers and notaries public becoming buyers of goods or rights involved in actions in which they are retained. 3. Where a sale is conducted in violation of paragraphs 1 and 2, such sale may be rescinded only by the seller, the opposing party in a civil action involving the goods or rights, or their respective heirs or successors in interest. 527. Goods that may be sold. Any good or right, including one that comes into existence in the future, may be the object of a contract of sale, except for goods or rights that are not transferable by their nature, or those as to which transfer is prohibited by law. Section 3. Effect of sale contract. 528. Transfer of Title 1. With respect to the transfer of title to the goods under a contract of sale, the general rules provided for in Articles 133 creation, transfer and alternation of real rights by agreement, 134 perfection, 135 requisites of transferring real rights of immovables by agreement, 160 acquisition of ownership over immovables and 187 acquisition of ownership over movable of this code shall apply to contracts of sale. 2. If the objectives of the sale and purchase contract are rights other than title to the property, with respect to the transfer of such rights, The general rules regarding the transfer of each rights shall apply to each contracts. Subsection I. Obligations of seller 529. Seller's duty to provide explanation. A seller is required to provide the buyer with a clear explanation concerning I. the contents of the obligations to be assumed by the buyer, and 2. the legal circumstances surrounding the goods or rights comprising the object of a sale, particularly, in the case of a sale of a movable property, the state of the title, encumbrances, boundaries, etc. 530. General obligations of seller. The seller owes to the buyer, in accordance with the terms of the contract and the provisions of this code, I. an obligation to transfer the property rights sold into goods, 2. an obligation to deliver the goods, 3. an obligation to preserve such goods until they are delivered, and 4. an obligation to deliver all instruments required to evidence proof of title thereto. 531. Obligation to transfer the right and warranty liability of seller. 1. The seller owes an obligation to transfer the property right of the subject matter of the sale to the buyer. 2. In the event that a right belonging to a third party is the object of a sale, the seller is obligated to acquire such right and thereafter transfer it to the buyer. 3. If, in the case described in paragraph 1, the seller cannot acquire the right and thereafter transfer it to the buyer may rescind the contract. In such a case, if the buyer was not aware at the time the contract was executed that the right did not belong to the seller, the buyer may also demand compensation for damages. 532. Rescission of contract by seller who sells right of another person. 1. Where a seller is unaware when a contract is executed that the right to be sold does not belong to the seller, and if the seller is subsequently unable to acquire the right and transfer it to the buyer, the seller may rescind the contract by compensating the buyer for any damages incurred by the buyer in connection with the attempted sale. 2. In the case described in paragraph 1, if the buyer was aware when the contract was executed that the right to be sold did not belong to the seller may rescind the contract without compensating the buyer for damages. 533. Warranty liability of seller when part of right sold belongs to another person. 1. If part of a right comprising the object of a sale belongs to a third party and the seller cannot subsequently acquire that part and transfer it to the buyer may demand a reduction of the purchase price proportional to the percentage of that part. 2. In the case described in paragraph 1, the buyer may terminate the contract if the buyer was unaware when the contract was executed that the part of the right did not belong to the seller and it is judged that the buyer would not have purchased the right if the object of the sale comprised the remaining part only. 3. In case described in paragraphs 1 and 2, if the buyer was not aware when the contract was executed that part of the right comprising the object of the sale did not belong to the seller, the buyer may also demand compensation for damages. 4. Where the buyer was not aware when the contract was executed that part of the right comprising the object of the sale did not belong to the seller, the buyer's rights as provided for in paragraphs 1, 2, and 3, must be exercised within 1 year from the date that the buyer became aware of such fact. Where the buyer was aware when the contract was executed that part of the right comprising the object of the sale did not belong to the seller, these buyer's rights must be exercised within 1 year from the date of execution of the contract. 534. Seller's warranty liability when encumbrance exists. 1. Where goods comprising the object of a sale are subject to a perpetual lease, usufruct, right of use, right of residence, servitude, leasehold, right of retention or pledge, and due to such encumbrance the buyer cannot enjoy the use of all or a part of such goods or receive profits therefrom, the buyer may demand compensation for damages from the seller if the buyer was not aware of the existence of such encumbrance when the contract was executed. In the case described in paragraph 1, if the purpose of the buyer's execution of the contract cannot be achieved due to the existence of the encumbrance, The buyer may also terminate the contract if the buyer was not aware of the existence of the encumbrance when the contract was executed. 3. The rules set forth in paragraphs 1 and 2 shall also apply to cases where a servitude that was represented as existing with regard to immovable property comprising the object of the sale does not in fact exist. 4. In the case described in paragraphs 1, 2, and 3, the buyer's rights to terminate the contract and to demand compensation for damages must be exercised within 1 year from the date that the buyer learned of such fact. 535. Seller's warranty liability when real security exists. 1. Where the immovable property to be sold under the sale contract is subject to a statutory lien, a pledge that bars the obligee from using or receiving benefits from the property, or a hypothec, if the buyer has lost ownership due to the exercise of such security interest, the buyer may terminate the contract. 2. If any costs or expenses are incurred by the buyer to preserve ownership, the buyer may demand reimbursement of such costs and expenses from the seller. 3. In either of the cases mentioned in paragraphs 1 and 2, the buyer may demand compensation for any damages sustained. 4. If the buyer of the immovable property which is subject to a statutory lien mentioned in paragraph 1, bought at the price which is deducted the price of the claim which is secured by the statutory lien, shall not have the rights mentioned in paragraph 1 through 3. 536. Seller's warranty liability in case of compulsory sale by public auction. 1. In the case of a compulsory sale, the buyer may, in accordance with the provisions of Articles 531, obligation to transfer the right and warranty liability of seller, through 535. Seller's warranty liability when real security exists, either rescind the contract or demand a reduction of the purchase price from the obligor. 2. In the case described in paragraph 1, if the obligor is insolvent, the buyer may demand from any obligee to whom any share of the proceeds has been distributed the return of some or all of such proceeds. 3. In the case described in paragraphs 1 and 2, if the obligor was aware of existence of the ground of the warranty liability and nevertheless failed to disclose it to the auctioning body, or if the obligee was aware of such non-existence and nonetheless demanded a compulsory sale, the buyer may demand damages from such parties. 1. Warranty by seller of claim. 1. The seller of claim shall be liable as to the existence of that claim. 2. Where the seller of claim warrants the solvency of the obligor, such seller is presumed to have warranted the obligor's solvency as at the time the contract was executed. 3. Where the seller of claim that has not yet become due warrants the future solvency of the obligor, such seller is presumed to have warranted the obligor's solvency as on the date on which the obligation is to be performed. 538. Agreement regarding discharge from or limitation of warranty liability. Even if it is agreed between the seller and the buyer that the seller's liability arising from the warranty set forth in Articles 531, obligation to transfer the right and warranty liability of seller, through 537, warranty by seller of claim, are discharged or limited, the seller may not be relieved of liability in regard to any fact of which the seller was aware and nevertheless failed to disclose, or in regard to any right that the seller created in favor of, or assigned to, a third party. 539. Obligation to deliver conforming goods. 1. The seller has an obligation to deliver to the buyer goods that conform to the contract. 2. Except where the parties have agreed otherwise, the goods delivered to the buyer shall be deemed non-conforming goods in any of the following situations: a. Where the goods do not conform to the quantity, quality and description required by the contract; b. Where the goods differ from those that the seller held out to the buyer as a sample or model in terms of their quantity, quality or description; c. Where the goods are not fit for a particular purpose expressly or impliedly made known to the buyer when the contract was executed; d. Where the goods are not fit for the purposes for which goods of the same description would ordinarily be used, or e. Where the goods are not contained or packaged in the manner usual for such goods or in a manner adequate to preserve and protect the goods. 540. Conforming goods warranty liability. 1. Where the goods are non-conforming in any respect at the time that the risk passes to the buyer, even if the existence of such non-conformance becomes apparent after the passage of such risk, the buyer may, in accordance with the terms of the contract and the provisions of this code, demand that substitute goods be delivered or that such non-conformance be remedied, terminate the contract or reduce the purchase price as against the seller rate. 2. The seller shall owe the conforming goods warranty liability described in paragraph 1, in regard to any non-conformance that occurs due to a breach of any of the seller's obligations, including any non-conformance that occurs after the time indicated in paragraph 1. 3. Where the seller warrants that for a certain period of time after delivery the goods will remain fit for their ordinary purpose or for some particular purpose, or will retain specified qualities or characteristics, if there is a breach of such warranty, the seller shall owe the same conforming goods warranty liability. 4. If when the contract was executed the buyer was aware that the goods were non-conforming in any respect, or was unaware of such non-conformance as a result of gross negligence, the seller shall not owe the conforming goods warranty liability with respect to such non-conformance. 541. Seller's right to remedy non-conformance. 1. If the seller has delivered goods before the date for delivery, he may, up to that date, remedy any non-conformance in the goods delivered so long as the buyer's interests are not unfairly prejudiced thereby. However, the buyer shall not be precluded from exercising the right to demand compensation for damages. 2. The seller may, even after the date for delivery, remedy at his own expense any non-conformance in the goods so long as the buyer's interests are not unfairly prejudiced thereby. However, the buyer shall not be precluded from exercising the right to terminate the contract and the right to demand compensation for damages. 542. Buyer's right to demand complete performance. 1. The buyer may demand that the seller, fully and completely, perform its obligations. However, this shall not apply where the buyer has resorted to a remedy that is inconsistent with such demand. 2. Where the goods are non-conforming in any respect, the buyer may demand that the seller deliver substitute conforming goods. However, this shall not apply where supplying goods of the same description would cause undue burden to the seller in consideration of the surrounding circumstances. 3. Where the goods are non-conforming in any respect, the buyer may demand that the seller remedy the non-conformance. However, this shall not apply where remedying the goods would cause undue burden to the seller in consideration of the surrounding circumstances. 4. The buyer may fix an additional period of time of reasonable length. The seller's liability covered under Article January 3, 2013 shall be referred to as conforming goods warranty liability in this translation. For the seller's performance of its obligations, unless the buyer has received notice from the seller that the seller does not intend to perform within such period, the buyer may not resort to any remedy for breach of contract during such period. However, the buyer is not deprived thereby of the right to demand compensation for damages incurred due to the delayed performance. 543. Buyer's right to terminate if the goods delivered are non-conforming in any respect and such non-conformance prevents the achievement of the buyer's purpose for entering into the contract, the buyer may terminate the contract. 544. Buyer's right to demand price reduction where the goods delivered are non-conforming in any respect, regardless of whether or not the price has already been paid. The buyer may demand reduction of the price by a percentage that reflects the difference between the value of the goods actually delivered and the value that conforming goods would have had at the time of delivery. However, where the seller has remedied the non-conformance in accordance with Article 542, buyer's right to demand complete performance, or where the buyer has refused to accept an offer by the seller to remedy the non-conformance without good cause, the buyer may not demand a reduction of the price. 545. Buyer's right to demand damages. The buyer may demand compensation for damages, in accordance with the provisions set forth in Section 3, Chapter 4 of Book 4, independently of or together with any remedies provided for in Articles 542. Buyer's right to demand complete performance. through 544 Buyer's right to demand price reduction. 546. Special provisions regarding excess or deficiency in area of land. 1. Where the total area of specified land is indicated, and a sale has been executed based on a fixed price per unit area, but the actual area is less than the indicated area, the buyer may demand, in accordance with the provisions set forth in Articles 542, Buyer's right to demand complete performance, through 545 Buyer's right to demand damages, i.e., delivery of the deficient portion. 2. A reduction in the purchase price reflecting the deficiency, or 3. Termination of the contract, and/or 4. Compensation for damages, unless otherwise agreed to between the parties. Where the total area of specified land is indicated, and a sale has been executed based on a fixed price per unit area, but the actual area exceeds the indicated area, if the seller was unaware of such excess without negligence on his part, the seller may demand an increase in the purchase price reflecting the excess amount of land, unless otherwise agreed to between the parties. 3. Where the total area of specified land is indicated and a sale has been executed based on a single price for the entire parcel, even if the actual area is less than the indicated area, the buyer may not demand, i.e., delivery of the deficient portion. 2. A reduction in the purchase price reflecting the deficiency. 3. Termination of the contract, or 4. Compensation for damages. However, this shall not apply to cases where I. The seller knew of the deficiency of the actual area, 2. The seller guaranteed the accuracy of the indicated size of the area, or 3. The deficiency exceeds 5% of the indicated area. 4. Where the total area of specified land is indicated and a sale has been executed based on a single price for the entire parcel, the seller may not demand an increase in the purchase price even if the actual area exceeds the indicated area. However, this shall not apply where the excess area exceeds 5% of the indicated area, and the seller was ignorant of such fact without negligence on his part. 5. In a case in which the seller demands an increase in the purchase price based on the provisions of paragraphs 2 or 4, the buyer may terminate the contract. 547. Period for exercise of rights. 1. The rights provided for in Articles 542 Buyer's right to demand complete performance, through 544 Buyer's right to demand price reduction, and 546 Special provisions regarding excess or deficiency in area of land, must be exercised within 1 year. However, the provisions of Article 482 Extinctive Prescription Period for General Claim, shall apply to the right to demand damages described in paragraph 1, and in the second sentence of paragraph 2, of Article 546 Special provisions regarding excess or deficiency in area of land. 2. The period described in the first sentence of paragraph 1, shall be computed from the dates identified below. A. For the buyer, the date that the buyer knew or should have known of the existence of the nonconformance or damage, and B. For the seller, the date of execution of the contract. 548. Special provisions regarding discharge from or limitation on conforming goods warranty liability. Even if the seller and the buyer agree to discharge or limit the seller's conforming goods warranty liability arising from the provisions set forth in Articles 540 Conforming Goods Warranty Liability, etc., the seller may not be relieved of liability in regard to any nonconformance regarding which the seller had knowledge and nevertheless failed to disclose. 1. Duty to deliver goods. 1. The seller shall have duty to deliver the goods to the buyer at the time and the place provided for in the contract. 2. If only the time of payment of purchase price is provided for in the contract, such time is presumed to apply also to the delivery of the goods. 3. If the contract does not provide for either a time for delivery or a time for the payment of the purchase price, the seller shall have duty to deliver the goods immediately after the buyer's demand for delivery. 4. If the place of delivery is not provided for in the contract, the seller shall effect the delivery, in the case of the sale of a specified goods, at the place where such specified goods was located at the time of the formation of the contract, and in other cases, at the domicile of the buyer. 5. The costs of delivery shall be borne by the seller unless otherwise agreed to by the parties. However, if the costs of delivery increase due to a change of the buyer's address, or any buyer's act, the increased costs shall be borne by the buyer. 550. Manner of delivery. Delivery of property shall be effected through actual delivery, delivery by declaration, transfer by direction, or constitutum possessorium in accordance with the provisions described in Article 229. Assignment of possession. The delivery of an immovable may be effected through the actual delivery of the keys to the structures comprising or residing on such immovable or of the documents evidencing title thereto. 551. Defenses of simultaneous performance. In security 1, the seller may refuse to transfer of the right or to deliver the goods until the buyer tenders payment of the purchase price. However, this shall not apply where the buyer's obligation has not yet become due or where it is agreed that the obligation to transfer the right or to deliver the goods is to be performed prior to payment of the purchase price. 2. Even where the seller has granted the buyer a grace period for the payment of the purchase price, if the buyer becomes bankrupt or insolvent after the execution of the contract, or has concealed his insolvency prior to execution of the contract, the seller may refuse to transfer the right and to deliver the goods. However, this shall not apply where the buyer has provided the seller with security or has otherwise taken a measure that has extinguished such insecurity. 552. Obligation to preserve goods. 1. The seller of a specified good shall preserve such good with the care of a good manager until it is delivered. The same rule shall apply with respect to the seller of a fungible good after specification thereof. 2. If a good is destroyed, lost or damaged due to the seller's failure to conform to the duty of care set forth in paragraph 1, the seller shall be liable to the buyer in accordance with the terms of the contract and the provisions of Section 3, Chapter 4 of Book 4 of his Code. 553. Right to acquire fruits. If a good comprising the object of a sale produces natural fruits before it is delivered to the buyer, such fruits shall belong to the seller unless otherwise agreed to between the parties. The same rule shall apply where the good produces rent or other legal fruits. Subsection 2. Obligations of buyer. 554. General obligations of buyer. The buyer is obligated to pay the purchase price to the seller, and to receive the goods that the buyer has purchased. 555. Obligation to pay purchase price. 1. The buyer has duty to pay the monetary purchase price agreed upon in the contract at the time and place agreed upon in the contract. 2. Where the sale contract of a movable provides only a time for the delivery of goods subject to the sale contract, or the sale contract of an immovable provides only a time for the acts required for the registration of an immovable subject to the sale contract, such time is presumed to apply also to the payment of the purchase price. 3. If the contract does not provide for neither a time for a delivery of a movable or for acts required to register an immovable subject to the contract, nor a time for the payment of the purchase price, the buyer shall have duty to pay the purchase price immediately after the seller's demand for payment. 4. Where the place to effect payment of the purchase price is not provided for in the contract, if the purchase price is to be paid simultaneously with the delivery of the goods or acts required to register of the immovable subject to the contract, the buyer shall pay the purchase price at the place where the seller shall deliver a movable or complete the acts required for the registration of an immovables. 556. Damages for delayed payment. Even where payment of the purchase price is delayed, the buyer need not pay damages for the delayed performance until he receives delivery of the goods. 557. Right to refuse payment when third-party claims interest in goods. 1. Where a third party claims an interest in the goods comprising the object of the sale, thereby resulting in a risk to the buyer of the loss of all or part of the right purchased by the buyer may refuse to pay the purchase price in proportion to the extent of such risk. However, this shall not apply where the seller has provided the buyer with adequate security. 2. In the cases described in paragraph 1. The seller may demand that the buyer deposit the amount of the purchase price with an authorized depository office. 558. Defenses of simultaneous performance. In security 1, the buyer may refuse to pay the purchase price until the seller tenders performance of his obligation. However, this shall not apply when the seller's obligation has not yet become due or where it is agreed that the obligation to pay the purchase price shall be performed prior to the seller's performance. 2. Even where the buyer has granted the seller a grace period for performance, if there is a significant risk of the seller's non-performance, the buyer may refuse to pay the purchase price. However, this shall not apply where the seller has provided the buyer with security or has otherwise taken a measure that has extinguished such insecurity. 559. Delayed receipt 1. In the event of a delay in the performance of the buyer's obligation to receive the goods, the seller may demand compensation for damages or terminate the contract in accordance with the provisions set forth in Sections 3 and 4, Chapter 4 of Book 4. 2. In the case described in paragraph 1, if the goods is destroyed, lost or damaged due to any reason other than the seller's negligence, the buyer shall assume the risk of such destruction, loss or damage. 3. If the buyer refuses to receive delivery of the goods even though the seller has tendered delivery thereof, the seller may deposit the goods with the official depository office or sell them in accordance with the provisions of Articles 457 Deposit and 458 Obligor's Right to Sell. Section 4. Termination of contract by exercise of repurchase right 560. Special agreement for repurchase 1. The seller may, based on a special agreement for repurchase that is clearly provided for in the written contract of sale, terminate the contract by returning the purchase price paid by the buyer and the costs described in Article 563 Exercise of repurchase. 561. Period for repurchase 1. No period for repurchase shall exceed 5 years with respect to immovable property and 2 years with respect to movable property. If a longer period has been fixed, it shall automatically be reduced to 5 years with respect to immovable property or 2 years with respect to movable property. 2. If a period has been once fixed for repurchase, it cannot subsequently be extended. 3. If no period has been fixed for repurchase, the seller must exercise the right of repurchase within the period set forth in paragraph 1 of this article. 562. Perfection of special agreement for repurchase against third parties 1. The buyer may exercise any and all rights associated with the owner. However, if such exercise contravenes the purpose of special agreement for repurchase, the buyer shall be liable for breach of the contract. 2. The special agreement for repurchase shall be effective even against third parties only if it is registered simultaneously with the execution of the sale contract. 563. Exercise of repurchase 1. The seller may not repurchase the goods sold unless he tenders the purchase price and all costs incurred in connection with the execution of the contract within the period of repurchase. 2. Where the buyer or a subsequent transferee has made expenditures in connection with the good, if they are necessary expenditures, the seller shall provide reimbursement for the entire amount thereof, while if they are merely useful expenditures, the seller must provide reimbursement of, at the seller's election, either the amount of such expenditures which the buyer or the person who bought the goods from the buyer made, or the increase in the value of the goods attributable to such expenditures to the extent that such increase in value continues to exist. 564. Sale including special agreement for repurchase of co-owned good 1. Where co-owners sell all of a co-owned good by entering into a single contract that includes a special agreement for repurchase, if one of the co-owners demands repurchase either of his share only or of the entire co-owned good, the buyer need not respond to such demand. 2. Where all co-owners sell their respective shares of the co-owned good by entering into separate contracts that include a special agreement for repurchase, each co-owner may repurchase his respective share separately from the other co-owners. 565. Effect of non-exercise of right of repurchase. Where a seller does not exercise a right of repurchase within a period fixed in accordance with Article 561 period for repurchase, the right of repurchase shall be extinguished, and the buyer's ownership shall not thereafter be subject to a demand for restitution. Chapter 2 Exchange 566. Definition: An exchange shall become effective by the mutual promises by the parties to transfer any property right other than money. 567. Mutatis mutandis. Application of provisions relating to sale. The rules relating to sale shall apply mutatis mutandis to exchange. Chapter 3 Gift 1. Definition: A gift is a contract which comes into effect when one party manifests the intention to give property to another gratuitously, and the other party accepts it. 569. Transfer of ownership. Transfer of the ownership of an object pursuant to a contract of gift shall be subject to the general principles provided in Articles 133. Creation, transfer and alternation of real rights by agreement. 134. Perfection. 135. Requisite of transfer of title by agreement pertaining to an immovable. 160. Acquisition of ownership over a movable, and 187. Acquisition of ownership over movable. 570. Gift not in writing. Even where a promise of gift is made, if it is not put into writing, either party to the contract of gift may revoke the contract by withdrawing his manifestation of intention, provided however that the manifestation of intention may not be withdrawn in respect of any portion of the gift for which performance has been completed. 571. Rescission of gift on account of breach of trust, etc. 1. If the donor commits a serious breach of trust against the donor shall be entitled to rescind the gift. 2. Rescission of a gift under paragraph 1, in respect of any portion of the gift of which performance has been completed may be effected only within a period of 5 years following the occurrence of the serious breach of trust. 572. Rescission of gift on account of poverty of donor. 1. If the donor is reduced to a state of extreme poverty and is no longer able to maintain the living of himself and persons whom he has obligation to provide with support after making a manifestation of intention to gift, the donor shall be entitled to rescind the gift. 2. Rescission of a gift under paragraph 1, in respect of any portion of the gift of which performance has been completed may be effected only within a period of 5 years following said performance. 573. Effect of rescission of gift. In the event of rescission of a gift under Articles 571, rescission of gift on account of breach of trust, etc., and 572, rescission of gift on account of poverty of donor, the donor shall be entitled to demand return of the gift in accordance with the provisions relating to the return of unjust enrichment. 574. Alleviation of warranty liability. The donor shall not owe warranty liability for any defect in or absence of the thing or right that is the subject matter of the gift, provided, however, that this shall not apply if the donor has knowledge of the defect or absence and fails to inform the donor thereof. 575. Periodic gift. Periodic gifts shall lose its effect on the death of the donor or the don. 576. Encumbered gift. 1. A gift of which the don is obliged to carry out a specified performance in order to receive the gift is referred to as an encumbered gift. 2. In the case of an encumbered gift, the donor shall assume the same warranty liability as a seller to the extent of the encumbrance. 3. In the case of an encumbered gift, if one party performs, such party shall be entitled to demand that the other party perform. 4. In the absence of specific agreement, one party to a contract of encumbered gift may withhold her performance until the other party performs. If the don does not execute the encumbrance, the donor of an encumbered gift shall be entitled to terminate the contract of gift in accordance with the provisions relating to termination. 577. Gift on donor's death. 1. A gift which is to become effective upon the death of the donor shall be referred to as a gift on donor's death, donatio mortis causa. 2. The provisions relating to testamentary gifts shall apply mutatis mutandis to the effect of a gift on donor's death. Chapter 4 Loan for Consumption Section I Definition and Formation of Loans for Consumption 578. Definition of loan for consumption. A loan for consumption is a contract whereby one party, called the lender, assumes an obligation to entrust the free use of money, foodstuffs, paddy or other fungible objects for a specified term to another party, called the borrower, who assumes the obligation to return objects of the same type, quality and quantity as those received from the lender upon the expiry of the said term. 579. Formation of contract of loan for consumption. A contract of loan for consumption is formed by agreement of the lender and the borrower alone. 580. Revocation of contract of loan for consumption not in writing. Either party shall be entitled to revoke at any time a contract of loan for consumption without interest that is not in writing, provided that this shall not apply to any portion of the object of the loan that has been delivered by the lender. 581. Termination for deterioration of borrower's creditworthiness. 1. If after the formation of a contract of loan for consumption but before delivery of the object thereof the economic situation of the borrower deteriorates and performance of the obligation to return becomes doubtful, the lender shall be entitled to terminate the contract. 2. If a lender who has terminated a contract under paragraph 1, has received interest, commission or other consideration in advance, the lender shall return the same to the borrower. 582. Quasi-loan for consumption. 1. If a person who assumes an obligation to deliver money or other fungible objects other than pursuant to a loan for consumption agrees with the obligee to make such objects the subject matter of a loan for consumption, a loan for consumption shall be formed thereby. 2. In cases described in paragraph 1, any security for the original obligation shall be presumed to be transferred to the new obligation. 583. Claim for interest. 1. Interest refers to that amount of money or other things calculated by multiplying